This is of the Appellate Division, 4th Department. Hear you, hear you, hear you. All persons having business before this court will draw near and give their witness. Thank you.
Thank you. Please be seated. Good morning. Justice Ogden is joining us virtually. You'll be able to see her on the screen to your right. The first case is People versus Ogden, no relation, 861. Mr. Keem is joining us virtually. He's scheduled to, there he is now. Mr. Keem, good morning to you.
Sorry, Your Honor. Good morning.
You may proceed.
May it please the court, Brad Keem, and I represent Javion Ogden. We assert that the trial court erred in failing to remove Javion's case to family court. First, I'd like to take an opportunity, hopefully better than in Guerrero, which I know Justice Keene was on, to explain why a balancing test doesn't effectuate raise the age. First, I would say that there's nothing extraordinary about 5 factors outweighing 4 factors. A balancing test is too subjective. It creates the risk that results across the state will vary tremendously. And it doesn't effectuate the presumption of removal. Now, Lloyd F. in the 2nd Department and Aaron V.V. in the 3rd Department, they've also adopted the use of a balancing test, but they also recognize that there's a sweeping presumption. Aaron V.V. used that language, a sweeping presumption for removal and the demanding nature of the legal standard. I think that's best expressed through our 2-part test, which, as I'm sure the court is aware, will be argued at the Court of Appeals in Guerrero.
Mr. Keem,
Yes.
There was a waiver of the right to appeal here. Can we reach this removal issue in light of the waiver, assuming the waiver is valid?
Absolutely. It's a jurisdictional issue. It comes before the waiver even occur. I mean, whether there's jurisdiction or not for the family court to consider the case, it would absolutely not be part of the waiver of the right to appeal.
Well, the way the people have advanced the waiver with respect to other contentions, but not this one. So they may agree with you on that, but didn't the youth part have jurisdiction of the court at the time it made its decision not to remove it? The court was properly in the youth part of county court. So youth court had jurisdiction at that time. Or would you disagree with that?
So youth court had jurisdiction. Then once they made the determination that it goes to county court, that youth part argument is not part of the waiver.
So county court didn't have jurisdiction. That's your
County court, correct.
Okay.
So along those lines, Mr. Keem, whether or not to transfer to family court is left to the court's discretion based on the statutory standards, correct? So,
Your Honor, are you referring to the balancing?
yeah, the decision is a matter of the court's discretion. It's not mandatory to transfer in all instances, correct?
Correct.
So if it's an issue of discretion, it would be akin to an issue of such as, off the top of my head, severance. So if it's a matter of a discretionary call, why would that not be encompassed by the waiver of appeal?
Because it's still jurisdictional in nature. What court considers it is still jurisdictional in nature. So the jurisdiction can never be waived, whether it's discretionary or not.
Well, you can waive your right to seek a transfer, or the people could waive their right to seek extraordinary circumstances. As I recall, the statute specifically says the defendant may waive the transfer to family court. So if they can waive it, it's really not an issue of subject matter jurisdiction, correct?
I suppose, Your Honor, what I would argue then is that if that's the court's perspective, I honestly, the people seemingly conceded it. I didn't even consider that it would be part of the waiver of the right to appeal.
Right. We understand this is all surprise you. It's unfair. We're not taking a position on the waiver.
Right.
We're just curious that it seemed to be valid with respect to some contentions, not this one. But why don't we return to your merits argument, if you would?
Thank you, Your Honor. In the event that the court, and I don't anticipate that the court will adopt the two-part test after Guerrero just came out, I would ask the court to provide more nuance when it does its balancing of the aggravating and mitigating factors. Specifically, the court should acknowledge that this is a sweeping presumption and it must be overwhelming for the people to demonstrate extraordinary circumstances. Extraordinary means extraordinary. And here, there's no evidence at all as to the amenability of services. In Lloyd F., they talked about when balancing to really be guided by whether the possibility exists that this adolescent can be reformed. And instead, the trial court here merely talked about the cruel and heinous nature of the actions of others, not necessarily my client who was the driver here.
And you're suggesting that should be the first part of the two-part test, but the second part, the strong proof that the defendant is not amenable or would not benefit from the heightened services in family court. Does it need to be, I mean, that's right from the legislative history.
Correct.
Does that need to be a test, or can the test still be, a totality of circumstances test, being mindful of the legislative history, which is done all the time?
Well, and I think that the problem, Justice Nowak, is that if it's simply a balancing test, there are courts like this one that are not going to discuss the amenability of services, that are simply going to talk about cruel and heinous, when in fact the language is highly unusual and heinous.
True.
It is not highly unusual for an adolescent to drive his friends, whether he knows that they have weapons or not. And that's unfortunate, obviously, but that does not make it highly unusual to be a getaway driver for a group of young people.
Factually on this, I know that there was some evidence or some information, it might have come out later, that this wasn't the first house they visited that morning, that they went to another house, knocked on the door, no one opened the door. For some reason, they didn't want to break through a lock. I guess it seems a little bizarre in light of what happened later. But it would seem to me that based on that, the defendant in this case was aware of the concept of home invasion. It wasn't a situation where they said, oh, give us a ride to the store, and then, I was shocked at what they did. That they were aware of this, that they had gotten ready to do another home invasion previously. Did the court know that when the court found extraordinary circumstances?
That's the interesting thing, Justice Nowak, is that the court didn't know that until after its determination. That wasn't properly before the court at the time it made its decision. And certainly, as the record reflects, and I was able to put in the harsh and excessive and youthful offender argument, there is a litany of mitigating material that I can't put before the court in this aspect of the argument because defense counsel didn't do that. But I think what this court must do is strictly look at the material that the court was aware of when it made the adolescent offender determination.
Mr. Keem, you make a lot of good points, and I'm inclined to agree with you on the removal issue. Guerrero, I was on Guerrero as well, and that was different. Guerrero, the young man, had been in family court getting services for 4 or 5 years to no effect, continued on. This defendant had not had any prior contact with the criminal justice system or in family court, no services. So you make some cogent points there. What concerns me is after the plea, prior to sentencing, he picks up 2 new separate weapons offenses. CPW second, and I think a 3rd or 4th degree. One was a 4th, one was a 2nd. And then there would seem to be an agreement. The defendant would waive outlay hearing for the enhancement. he would get a more severe sentence and the people wouldn't go forward with those new indictments. So if we were to remove the case to family court now, based on your arguments, which are all rather persuasive, is that not unfair to the people? Your client, then the two CPWs go away. He gets time served, no record, and he's in family court with 16, 17, 18-year-olds. Do you see any unfairness to the people in that situation?
Your Honor, my understanding of the record is that he was arrested on the CPW and it was no billed by Monroe, that Wayne County didn't have control over those cases in any aspect. This was about Wayne County.
Yeah, well, he got an extra, 6 years for the enhancement. It seemed like what the deal was, all right, we're just going to enhance him out there and not go forward. The record's not entirely clear, but if there was no basis for the new arrest, why would your client waive his Outley hearing? He should have gone forward with the Outley hearing.
I don't disagree with that, Your Honor, but I don't think that we can make those assumptions, especially considering that it was no billed. And that is in the record by stipulation.
Okay. You want to address the youthful offender or any of your other points?
Yes, I'm the youthful offender. If the court elects not to consider or not to provide adolescent offender, I know that in Guerrero, the court elected not to give him youthful offender either, but the mitigating factors applied here. I go through the Crookshank factors in detail. I think that the court erred then in denying him youthful offender adjudication. I don't know if we have to go through all of them in detail, but if the court does not provide that remedy, it must reduce this sentence.
Doesn't the waiver, the people do, I believe, exert the waiver with respect to the sentence in NYO. How do we get around? Is this a Hannity situation?
Hannity, yes. Hannity is the case, of course, that I'm going to be citing, because this is where injustice or prejudice, the guideposts are all passed. There's a potential that if the court finds that the adolescent offender is covered by the waiver of the right to appeal and the youthful offender is not preserved, there's no way a 12-year sentence is appropriate when the individuals who are actually involved in the violent acts received 8 years. The probation said that he should get 6 months, a split sentence. He has no criminal history. He graduated high school during the pendency of this action. He showed remorse. He accepted responsibility. He has a need for drug treatment. That's not uncommon for an 18-year-old or 17-year-old.
Mr. Keem, let me take you back to where our Justice presiding was a second ago on the YO adjudication.
Yes, Your Honor.
I'm looking at a stack of our cases, and just to emphasize the point, we have a case called People versus Stackhouse from 2023. Justice Ogden, I think, was on that. People v. Hinson, Justice Ogden and Justice Linder on that. I mean, I could go through at least a dozen off the top of my head based on my notes, but each one of those cases provide that the YO determination is barred by the valid waiver of appeal if it's valid. In addition, that same waiver of appeal, if it's valid, precludes our interest of justice jurisdiction from considering that contention. We said that repeatedly. So are you relying on Hannity to get around the waiver of appeal vis-a-vis the YO adjudication and the declination thereof?
Absolutely. Well, first and foremost, I'd argue the waiver was invalid, and that would make this court's job a lot easier if it could say that the waiver was invalid. But Hannity, there's no difference in arguing that or in asserting that this court is able to review harsh and excessive sentence than it is to review youthful offender adjudication.
That's the interesting part for me. And as you know, I was in dissent on Hannity. So, but here for YO adjudication, it replaces the criminal adjudication, correct?
Correct.
So it really is not just looking at a legal sentence. Remember, 470.15 subdivision 2 allows us to have interest of justice jurisdiction vis-a-vis a sentence. So it's unpreserved issues, and secondly, a sentence that is legal, but we find is harsh and severe. There's nothing in that statute that Hannah T and the majority says was constitutionalized in some fashion. There's nothing in that statute that says we can convert a legal sentence to a YO adjudication. My point being, if we interpret Hannah T to that extent, doesn't Hannah T basically say we can do interest of justice jurisdiction on any issue?
Well, Your Honor, I would, as a defense counsel, that sounds wonderful to me. But I understand the court's concern. I think by narrowing it to sentencing issues, which youthful offender certainly is, it wouldn't open the floodgates, especially because this case is special. This is, in my 18 years of doing this, I am flummoxed by the different errors that were made in terms of the treatment for Mr. Ogden in terms of sentencing and rehabilitation and understanding the goals of adolescent justice and sentencing. So many of the guideposts that the law has provided were just blown over in this case.
Right, and you're running short on time, but I would just point out, I think, as I read the majority, they thought they had the ability, despite the waiver, to grant the defendant YO. They chose not to exercise that authority in Hannah T, but that's the majority. I think their analysis would also apply to YO. But as Justice Curran said, I think the analysis majority there would allow any issue to survive a waiver, including the removal issue, point one.
Did you,
Your Honor,
go ahead, sorry.
go ahead. I'm sorry. Go ahead, Justice Curran.
No, I should allow you to finish with the Justice Presiding's question. I'm sorry.
I completely agree with Justice Lindley, and I'm curious as to Justice Curran, how you're going to respond to the question for me.
Well, thank you for your interest, Mr. King. But I'm looking at Hannah T. To my recollection, first and foremost, the majority, they first said that the valid waiver of appeal precluded the review of the discretionary YO determination, including not reaching to justice. And then at the very end of the majority, if you recall, they said, oh, we do have this power, so we could do it. Do you find those two positions in the majority opinion, knowing that I was in dissent, but do you find those two positions in the majority decision somewhat contradictory?
I do not. I find that they thread the needle perfectly, and I would encourage the court to adopt the majority's opinion in Hannah T in a case like this that will allow it to review these very important issues. And unless there are questions, I will rely on my brief on our other issues.
Thank you, Mr. King.
May it please the court, Catherine Manikotz for the respondent. Sorry, I'm losing my voice. I would like to address, first of all, the jurisdiction issue that was raised by the waiver of right to appeal. There's no clarity like you have the night before you're preparing for an argument. And it occurred to me that I had not argued that. There is a recent case at the Third Department, which says, I believe which I haven't.
Yeah, we've seen that. We've all read that one.
But I disagree with that. I did not argue with it.
Was it inadvertent, or did you, at the time you wrote the brief, thought that the waiver didn't apply to the removal issue? It
was inadvertent in that I followed Mr. Keem's brief and then addressed the waiver in the next without addressing the jurisdiction issue. And addressing it directly occurred to me as I was preparing last night.
Because one could argue, we've had a case called Works, People versus Works, and there's a theory that the people can waive or forfeit a waiver by not asserting it.
Right.
One could argue here, you asserted it on other points in the brief, but not this one. So maybe there's a waiver of the waiver by your office. Do you care to address that?
That was not my intention. I thought that by addressing it later on specifically would cover that issue, as I said, and not addressing it specifically was not a conscious decision per se, but I thought it would be covered by me later on saying, but I could see how not addressing it would appear that way.
I mean, Counselor, as I understood it, you we see this all the time. The defendant has 5, here it's 6 contentions, and you went and did point by point, contention after contention. And also with respect to the justice presiding's question, I look back at works as well, and I was in concurrence on that on the waiver theory. But there, looking at the language that we used in the concurrence, we said that the people had affirmatively asked us for the relief. That is, you essentially exercise your prosecutorial discretion, which you're allowed to do, to say, get rid of the surcharges. So, but you didn't do that here. You simply said you were silent on the issue, but you stuck up for the waiver, generally.
Correct.
Okay.
Unfortunate.
Yeah.
I'm not sure that made any sense, but it did to me for a second.
Yeah, I guess your point on that, and then we'll move on to the merits, is that you did not affirmatively, intentionally waive anything. You just,
Correct.
you neglected to address the issue in point 1. And so you're not conceding anything on the waiver today. On the merits, with respect to the removal, if we can get there, Guerrero, do you agree there's some factual that this is distinguishable from Guerrero on with respect to the defendant's prior history in family court?
I do, but I don't think that ends the inquiry here. The fact that there is no prior history to look at doesn't change the facts of this case, which seems to me to rise to the level of heinous nature, although that's just wording or verbiage. That's not the right word. Those are terms used in an assembly debate, which were not thereafter adopted by the Senate or by the statute itself. And I think in the dissent in that case even mentions that there wasn't an assembly sponsor specifically of that bill. So to hang our hats specifically on whether it's a heinous nature, I would argue that it is.
You think
4 people being
to
shot,
be-
3 guns.
To be an accessory to a violent felony is heinous?
No, the nature of the case itself, the facts, having 4 weapons, 1 person being slashed with a machete, the other people being shot, 2 handguns, a shotgun. This is different from Guerrero in the sense that the facts of the case are more heinous. Now,
Well, in Guerrero, Guerrero took a more active role. But look, what happened in that house was heinous. The defendant says, look, I was just out in the car. I wasn't part of that, but there's no doubt he aided and abetted them by driving them away from that scene. He can't get around that, but so that's a close question we're gonna have to look at.
as to the fact that they were driving around earlier, I think Mr. Keene said that was not brought to the court's attention. It's actually contained in page 33 of the appendix where the people brought that to the court's attention, which I noted. It also appears from the 911 calls.
Yeah, everyone's losing you on the screen here.
Right.
Yeah, if you could keep your paper, that's okay. Just keep your papers
I'm
at the
sorry.
podium, it'd be great, thanks.
It also appears, then I'll drop them, but I will try to do that. It also appears from the 911 calls that day that this was not the only location that these defendants went to with masks and weapons. So the court did consider that, and I think it was in the court's decision. Sorry again, I won't do that again. That those were the facts. But the defendant says in the PSI that that's where that information comes from, that he was just there. He was there to play video games, but he sat in the car with a mask on, and albeit this could have been during COVID when people were wearing masks. But he didn't go inside to play video games. He stayed out in the car. It was his mother's car. They had been to this prior location. I can't think of a more terrifying situation for the people that lived there, for these 3 people to come in with guns and a machete, and for the woman to run into the bedroom and then be slashed with a machete. So it's not a situation where she ran and they left her alone. They affirmatively attacked her. And that's the person who jumped out of the window. My understanding is he was bleeding, if I recall correctly from the record. And then the defendant drove away. He was arrested shortly thereafter, but the other 2 defendants were shot and injured. So they were there when the police arrived. So I don't think that and to prove, sort of go along with those points, we talk about specific crimes not being eligible. And I know there's some debate about that. But if this had been a murder, which it easily could have been, we wouldn't even be talking about that. So the nature of the crime itself has to be a consideration, at least in my determination of what we have available to us, which right now is cases from the different departments. And this may very well be determined soon. I know there are other cases in the Court of Appeals about this issue, but
Guerrero itself is going to the Court of Appeals.
pardon me?
I think People versus Guerrero is scheduled for argument in the Court of
I
Appeals.
think you're true. Mr. Keene can let us know that. I looked it up this morning just to see also. So obviously there's more direction to be had on this, just as there was with Bay. But I think if we look at the statute itself, we give the sentencing court a lot of discretion on a lot of things. This is the court that dealt with the facts of this case, read all the things that are available, made all the right determinations. I guess at what point, when we're talking about exercise of discretion, if the statute itself doesn't say that it has to be of a heinous nature and that the defendant wasn't amenable to treatment, what direction do we have for the courts? And I guess it's the case law here, but given the facts of this case, I don't see of course, there are more heinous factual patterns, but this case in and of itself is heinous. Would you like me to move on, or?
If you would like to, sure.
That's a loaded question, but I can keep addressing that if you like.
I think we've heard enough on the removal.
Okay,
If you want to, you do assert the waiver with respect to the YO
Correct.
contention and the sentence.
yes, Your Honor.
And it really comes down to Hannah T. Hannah T, we know applies to the sentence, a little ambiguous if it applies to YO. You want to weigh in on any of that?
I do, Judge. I just want to note that neither Mr. Keem or I addressed Hannity in our briefs. This was, I believe, submitted before the decision in Hannity. But yes, and of course, I agree with Justice Curran. I think those, and I read it and trying to figure out in my mind how you can reconcile those two things. I think that in that particular case, the facts of the case were that, and I believe, if I'm recalling correctly, that was a domestic violence situation, which the court specifically said could have been addressed in that manner. So taking all those things into account, perhaps the court felt in this particular case, under these particular facts, the interest of justice required them to step in. I can't really consolidate it in my mind, and I think that there's not a situation where your interest of justice jurisdiction is taken away from you by, at a constitutional level, which is what I believe the wording of that, where there's no statutory taking away of that right. Sorry if that's, so I would have addressed that more, and so I apologize that I'm, although very familiar with it and did look it over myself. So did that answer Justice?
Yeah, no,
and Justice
we
Lindbergh?
understand and I think we have your argument.
Okay, thank you.
Thank you very much. Case number 863 is People versus Rouse. Good morning, Ms. Stair.
Morning, Your Honors. Stephanie Stair for Mr. Rouse. Very briefly on the waiver of appeal, the language used by the judge when doing the oral waiver created ambiguity as to whether the listed rights were inclusive or exclusive of what survives. So our position is that the waiver is invalid and this court can reach the merits of the remainder of the brief. Point 2 is a 3032-45 issue. Up front, I'm not sure why I claimed constitutional speedy trial in my brief. It's clearly a statutory argument, so the respondent is correct in that. The only COC filed in this case was July 25th, 2021. Which was invalidated when a fake DNA report was not handed over until September 30th, 2021. On June 14th, when the parties were still within the 20-day automatic discovery timeframe and before the COC was filed, defense counsel informed the ADA that it was missing. The ADA did not respond. And that was even before the amendments that required defense counsel to alert the ADA that things were missing. So everything was done right. No response was given. When it was handed over, it was that September 30th date. All the DA had to do was go out in the hallway and ask the cops for a piece of paper, and defense counsel had it to hours later, less than 2 hours later. I think it's quite clear that even a minimal amount of due diligence was not done up until that point. It is not a coincidence that these are the exact same parties as the Tashad Beeson case that this court decided recently. Justice Presiding Lindley, Justice Curran, and Justice Ogden were on that panel. This is the same judge, the same DA, the same defense counsel, and pretty much the same time period. Importantly, a supplemental COC was not filed after that DNA report was turned over. So the people have never properly declared readiness in this case. Because they never properly declared readiness, the excludable time analysis is relatively irrelevant. But there are some periods of time that the court below told that should not have been told. There was post-readiness delay, readiness in quotes, when defense counsel, the ADA missed their deadline for motions, had to be adjourned for 14 days. The original hearing date had to be adjourned because of prosecution witness issue. And the hearing was not ultimately decided until 52 days later.
We have the calculation that you did, and then we also have the people's calculation on page 11 of their brief and how they get to only 114 days. It seems to me in going back to your brief on page 19 that really the issue comes back to this idea of the overlapping types of delay.
Right.
And you cite a New York City criminal court case from 1979 that was affirmed by the appellate term. And then you have a Courthouse City Court case from 2020. Is there any other authority for this concept of overlapping types of delay because it seems to me that if we don't accept that, we're left with page 11 of the people's brief in the 114 days.
Well, the overlapping delay, the only other authority really is common sense if you look at it, because the fact that defense counsel filed motions and the DA had to respond didn't prevent him from being like, hey, this piece of paper is missing. Can I please have that? Especially when you look at it in light of the fact that before motions were filed, before hearings were requested, he was told it was missing.
Right, there's no causation is your argument.
Right, exactly.
The delay was not caused by the motions.
Correct.
Because we have to get by the waiver
Yes,
because it's just a statutory speedy trial, not constitutional.
correct.
So we're gonna have to take a close look at that waiver. I think we may have approved waivers from the same judge, similar, but we're gonna compare it to the model colloquy and
Right.
see how it looks.
So I would, just to alert everyone, the judge who took the waiver was a different judge than who did the hearing and everything. It got switched halfway.
Yeah.
I would just,
I mean, we have the argument that you make is with respect to the waiver, page 14 of your brief is that the court only mentioned the limited number of claims that survive, only listed 5 claims that survive. The court did specify with respect to speedy trial, constitutional speedy trial. So we have that. We've got some cases, we have a lot of cases that talk about, that there's no requirement that the court provide an exhaustive list.
Right.
Here, the court specified the suppression decision also. I mean, so it seems like the court went even further than others have. What's your take on that? I mean, should we depart from those cases?
it's just, it is splitting hairs, and it is, arguing semantics in terms of her saying most claims survive or most claims are waived instead of saying it's only these 5, and do we need to spoon feed it? I think we do. I was a trial attorney for 15 years. Really technical legal concepts are not as clear to these defendants as they are even to us. And I wrote an entire brief saying constitutional speedy trial, and I meant statutory. So, I'm splitting hairs and I'm arguing the one word makes the difference, but I think one word makes the difference.
If we were to agree with you and say, there should be some sort of a step taken during the colloquy process where somebody says, all right, let's go through all the rules. Let's have the ruling conference. We can make it up the name as to what we're supposed to do.
Mhm.
Do we need legislation for that? Does the legislature need to step in and create this thing for waivers of appeal, or is this something that the court should just expect happens in the future?
I don't think
How do we get there is my point.
I think it's just on the judges to be more thorough. to make sure that the defendants truly understand what survives and what doesn't.
Because of the knowing and intelligent requirement.
Right,
That's what makes it knowing and intelligent.
right.
Are you suggesting, Counselor, then that and it's fair if you do, but I'd like to know that the CJI, model colloquy, you're saying that that's insufficient?
I think in a lot of cases it is, yeah. Because we're not-
And Wilson seemed to suggest that it was sufficient. They took that opinion in 2019. I don't know if that'd be their opinion today. But rest assured, we're gonna take a very close look at that waiver, see if we can get to your speedy trial.
If there are no more questions on speedy trial, I'll move to point 3.
Sure.
The parole records that were used in the hearing were heavily redacted and cross-examination of defense counsel was severely limited. The witness in this case was not a confidential informant. It was not so designated by the DA. The DA was correct in that he didn't have to do so on motion, but the statute says he still must notify the defendant in writing of the information that's not being disclosed. He clearly didn't do that under paragraphs 2 and 23 of the COC, where he could have done that. He marks not applicable. There was no protective order sought under 250-70 sub 1. And the law under which the lower court deemed the parole records to be confidential is basically the FOIL statute. FOIL is meant to protect details when John Q. Public requests information without a reason, right? But this was not a public inquiry with no purpose. It was a court order in relation to a criminal proceeding. And our position is that Mr. Rouse's constitutional right to confrontation and due process trumps FOIL laws. And the court below relied upon statutes that govern parole's internal regulations as opposed to, juxtaposed to Mr. Rouse's right to present a defense.
I don't disagree with you that the redaction was dramatic here. When you look at how the text was covered. But I also saw it in the exhibits, page 34 and 35 of the exhibits. There were other references to the fact that the person who called in was the girlfriend. I mean, page 34, defendant shook his head, wanted the parole officer to look into his girlfriend who called him in. And then there's another one, 35. Defendant has been harassing girlfriend, sending X-rated videos of hers to others without consent, is making a police report. States defendant has a gun. I mean, it's sort of, so yeah, we have this dramatic redaction, but then we have other unredacted records that really, doesn't that sort of make that argument less meaningful?
No, that actually helps my argument, right? So he obviously knows who this person is.
Right.
Right? So the records, yeah, we know who it was. But in terms of when you go to the hearing, the defense counsel was prevented from cross-examining when he got even remotely close to anything about her identity or what she had said. The court would interject and halt the line of questioning saying, I've read the unredacted things, you can't ask that. So what the defense counsel was able to get out was that the civilian witness didn't reveal her basis of knowledge for knowing that he had this gun allegedly. So without further exploration into that basis of knowledge and being able to question about her and what the telephone call was about and those types of things, I will quote defense counsel, it was at best an unfounded allegation in violation of his due process. So it's not the actual redactions that are the problem.
It's limiting on the question.
Correct. And when you add in the fact that even though the parties agreed a Darden hearing would probably be appropriate, the court sua sponte said, no, we don't need to do that. So we would be asking this court to remit for a new hearing without those restrictions and without those redactions. And if there are no other questions, I will rest on my.
Thank you, counsel.
Thank you.
Good morning. May it please the court, Bridget Field on behalf of the people. I would argue that the waiver appeal was valid and it was supported by a written. Not only did the oral colloquy meet what would be suggested in the model colloquy, there was a written waiver of appeal that was also signed by defense counsel and defendant was asked if he had signed a written waiver and that had had the opportunity to go over this with defense counsel. I do not think that, as Justice Noack and Curran were kind of asking, for judges to go through every ruling, every step in the case is not currently the law and has never been held to the law. Where would this stop as to each thing that's happened in a case in terms of a model colloquy? It's absolutely not suggested in the model colloquy.
And Ms. Field, as the Justice presiding alluded to before, at least on our end, and I'm assuming the lawyers do this too, where they can, we look at who the judge is, what the oral colloquy is, and what the written waiver is. And we kind of keep track of that even more than informally. So what we'll have to do, as the Justice presiding indicated, is get back to see if there's anything from this particular judge who did the plea colloquy, to see if there's something in a transcript that corresponds to this and if we approved it before. So we're gonna have to look at cases like that, but that's sort of the citations that we hope to expect or sometimes get on that issue. So it's gonna be tracked, judge colloquy. And by the way, over time, many judges have changed
That's
colloquies once the model became more familiar.
And it is my belief that this written waiver has been approved by this court, and that the colloquies by this judge, at least close in time to this case, have in fact been approved. And this is the newer waiver. There were some different waivers that were being used by our office sometime prior. This is the newer waiver that has been approved by this court in other cases.
If this waiver is valid, does it cover the limitation of the questions that were asked at the hearing, and then also the court's decision to not conduct a Darden?
I believe it absolutely does. I believe all the other issues would be waived if the waiver is approved by this court.
On the merits, do you wish to rest on your thorough brief, or do you wish to be heard further here?
I would be happy to rest on my thorough brief unless anyone has any questions.
Thank you.
Thank you.
Case 864, People versus Charles H. Wilson. The Banizak will be arguing virtually. Good morning, Counselor. You may proceed.
Thank you, Judge. Good morning, and may it please the court, Peter Banishak for Mr. Wilson. The trial court in this case erred in admitting Patricia Camel's hearsay statements to Officer Schoen because those statements did not fall within the so-called pedigree exception to the hearsay rule. There was no...
Wasn't there, excuse me, Counselor, wasn't there an agreement that was made though? I believe the defense counsel said that's fine in allowing those pedigree. There was she allowed that to happen, correct?
No, Judge, I would respectfully and strongly disagree with that contention. And for this reason, at page 549 of the record, defense counsel specifically argued that any statements made by Patricia Camel or specific statements made by Patricia Camel to the officer would be hearsay. The prosecutor responded that those things would be pedigree information and admissible. The trial court then ruled that they would in fact be admissible. So we have a ruling made by the trial court prior to any so-called agreement being made. And I think that's important because when we look at...
So your argument is that it happened afterwards? She said that's fine after the judge made a ruling?
Absolutely, Judge. And so when you take counsel's statements in sequence, she's saying that's fine because she's acknowledging the lower court's ruling that Patricia Camel's statements are in fact admissible under the pedigree exception. Counsel made further arguments about other things not falling within that exception, namely Mr. Wilson's residence, but she was simply trying to salvage at least a partially favorable ruling in light of what the court said about the pedigree information.
What was it? I'm sorry, I'm going to ask you another question, which is what was it that was so I guess, wrong with the pedigree information, because his address came out by the video where he said there was a burglary at his house, I think in 2018, I think it was.
That's correct, Judge.
He has the keys to the place and he's showing the officer around. He says that his girlfriend and her mother lived here. And I think he was claiming that there was jewelry stolen up in an attic.
Judge, I think respondent's brief views each piece of information in isolation and as though it's innocuous. And I would respectfully suggest that that's simply not the way that the jury would have viewed it. It has to be viewed cumulatively and in context. So we have police arriving on the scene to a complainant who says she has been shot at, that her address is 162 Conkey Avenue, and that her husband is Mr. Wilson. I think any reasonable juror would understand that this declarant is telling police that she was just shot at by her husband at 162 Conkey Avenue, because when police respond to a shooting, they don't ask simple pedigree information. Where do you live and who is your spouse? They ask you, where did this happen and who did this? And so
that's the argument that you make also with respect to the missing witness charge and why it was ineffective to not seek that. In looking at the summations, it looks like that the both sides appreciated the fact that the jury understood that Ms. Camel's vehicle had been shot at, but that they hadn't linked up the idea that the defendant did it. I mean, it seems that both parties, both attorneys at least, got away from that. The question was really just whether he had knowing possession of the firearms that were found at the house, irrespective of the shooting. And so, go ahead.
I'm sorry. I think it's fair to say that the attorneys did not make that specific argument. However, the prosecutor, I believe it's at page 815 of the transcript, did indicate that Patricia Camel's statements came in for their truth. That is to say that she lives at 162 Conkey Avenue and that Mr. Wilson is her spouse. I think the reality is, Judge, from and I'm sure you know this from presiding over trials, is that juries don't always hang their hat on the things that attorneys argue either in opening statements or summations. They are able to listen to the evidence and draw their own conclusions. In this case, the trial court never instructed them that Ms. Camel's statements were not coming in for their truth. And so the jury was very much able to draw the conclusion that based on Camel's statements to Officer Schoen, Mr. Wilson had just fired a handgun at her at 162 Conkey Avenue, and that provided a direct link for the jury to the guns that were ultimately located in the home. And
Mr. Benezek, look, I agree with you. Pedigree exception to the hearsay rule did not remotely apply here. I think the parties, the prosecutor may have been under the misapprehension they were talking about pedigree exception for Miranda. Separate pedigree exception. There's Miranda, and then there's hearsay. Hearsay is not even in the universe of being admissible here. This testimony shouldn't have been allowed. The question is, was there an objection? Was there an agreement, as Justice Kane had said? Your client's lawyer below said that's fine. Pedigree information from her is fine. It's not fine, but said it was, and then didn't object when it came in. So the question is it preserved? And if not, you argue in the alternative that your client was deprived of effective assistance of counsel by the trial lawyer's failure to object. When we get to that, just looking at the nature of the testimony here, I believe the objective testimony is on page 564 of the transcript. One of the things she said is that her husband was Charles Wilson. That's not terribly prejudicial. We heard from Charles Wilson 2 years earlier, and he says he lived with her on and off. And so that relationship's established elsewhere. She said she lived at 162 Conkey. That's one of the hearsay statements you challenge. We know that from other evidence. Really, the only one is that she said she was shot at. But we have the video of her with the police, no audio, but we have the video. clean as day, watching that video, the windshield of her motor vehicle was shot through on the passenger side. It's clear as day. The police officers testify they found lead from a bullet in that car. This was 15 minutes after 911 was called. So it's not going to be a shock to the jurors to learn that Ms. Campbell was shot at. She doesn't say here she was shot at by anyone in particular. So in any event, the question is like, if it's not preserved, do we reach an interest of justice? If it's not preserved, do we say that it is so egregious of an error that it deprived your client of meaningful representation? That seems to be the issues.
Judge, I'm going to try to address a number of points you made there, starting with preservation and defense counsel not objecting during the actual testimony. I think counsel's argument prior to the testimony was effectively a motion in limine asking the court to preclude statements made by Ms. Campbell. And critically, the trial court said, this is pedigree information. While you can object during the testimony, it's going to be pedigree information. So there was absolutely no reason for defense counsel to object again during that testimony in light of the trial court's ruling.
Right, but I think the argument is she clarified what her objection was. Her objection was pedigree information about the defendant, not pedigree information about the witness. That seemed to be her objection.
Judge, with respect to this argument about clarification or refinement, respondent's brief doesn't cite a case that stands for the proposition that counsel can somehow, or that counsel waived or retracted an argument made after the trial court's ruling. I think if this were a case where defense counsel and the prosecutor argued back and forth, defense counsel refined her argument at that point, and then the trial court issued a ruling, then I would be on much shakier ground, or I wouldn't have a leg to stand on. But that's not the sequence of events here. The trial court made a specific ruling, and I think defense counsel's statements after that ruling have to be viewed in context as acknowledging that at minimum, the personal information that Ms. Campbell provided to police was going to come in under this pedigree exception. And so she was saying, fine, Your Honor that's fine. Your Honor said those things are coming in. I have to accept that. But then I also don't want this other information coming in about where Mr. Wilson lives. So I would respectfully ask the court to re-review that portion of the transcript and take a look at that sequence of events. And with respect to the innocuous nature of those pieces of information as to the address and Mr. Wilson's marital status, I think, I'm resting on the argument I previously made, that my point is not these specific pieces of information viewed in the abstract. Of course, those are largely inconsequential. I think the court has to take a look at when those statements are made and why are they made. I think we have to assume that when a police officer arrives on the scene, in regard to a shots fired call, he's asking, where did this happen and who shot you? And the information that he received is this happened at 162 Conkey Avenue and Mr. Wilson shot me. So I respectfully submit that that's how any reasonable juror would have viewed that information. And that's why it's so prejudicial, because it does create that direct link that at some point, moments earlier in that night, that gun was in Mr. Wilson's hand. And it's not merely a matter of evidence of address and marital status.
But just to be clear, and then we'll move on. She didn't testify that her husband shot her. I don't believe. You're saying that the jury would infer from her statements that the husband shot her. Is that correct?
That's correct, Judge. I think any reasonable juror would have to. I don't mean to belabor the point, but again, given the context and the timing of those things, any reasonable, I think we have to give jurors credit that they would be able to draw those, I think, what are essentially basic links and deduce the fact that Ms. Campbell was providing that information because it was directly relevant to her complaint about having been shot at.
Mr. Bazik, I have and I just need my memory refreshed here. Did the court rule along the lines that the information that was objected to by defense counsel that we're discussing was background information or there to complete the narrative? And my question ultimately is, can we under Concepcion or LaFontaine conclude that that information was with respect to what was objected to, that is for background or to complete the narrative? So let me switch gears. Forgive me for doing this on the fly, but there was an objection to the statement that we responded to a call for somebody who was shot at, and there was an objection. Can we look at whether or not that information was background information or offered to complete the narrative?
I don't believe so, Judge. Counsel made a specific hearsay objection to that piece of testimony. The lower court overruled the objection and did not issue any sort of limiting instruction to the jury. And so there's no reason to believe that the jury would have understood that that testimony was coming in for some non-hearsay purpose. And I believe the case we cite in our brief is People v. Harris from the Court of Appeals, which indicated the need for such a limiting instruction if a piece of otherwise hearsay testimony is not coming in for.
I think Justice Kern, he can speak for himself, but I think his question related to Concepcion and whether we can affirm on a different ground there. The objection was hearsay. This is the one clearly preserved objection. The question was, and what was the nature of that investigation? It's a question to the police officer, and the answer was it was for a person that was shot at. The defense lawyer objected. On hearsay grounds, the court just said overruled, and they moved on. So no reason was given, which means we can fill in the blank. That's what constitutional allows us to do. If the court doesn't give a reason, we just pick any one that we think fits. If the court gives a particular reason, we're stuck with that one.
Judge, my position is that Concepcion does prevent the court from affirming on that ground, specifically because the trial court did not issue a limiting instruction to the jury. If that piece of hearsay testimony did not come in for its truth, the typical practice is that the court will advise the jury that you're not to take that for its truth. It's just to show
that's a legitimate point.
To show what the officer did. That didn't happen here, nor did it happen with respect to the other pieces of testimony that I'm contending should not have come in. The court's ruling specifically was that it is admissible under a hearsay exception, not for some non-hearsay purpose.
Thank you very much, Counselor.
Thank you.
Good morning, Your Honors. Aaron Schwally for the people. I will certainly welcome the court's questions with respect to reservation, but even assuming there is that anything here is preserved, the statements made by Ms. Kamel that came in through the officer's testimony, I would submit that any error is harmless.
Would you, just to be clear, you're not trying to defend the ruling here based on pedigree, exception to the hearsay? You're skipping over that part, right?
Sure, but Your Honor, I would submit that basically any objection to what came in through Officer Schoen on appeal is not preserved based on what.
So it's an error. There was a mistake here. The prosecutor's relying on the wrong ground. Shouldn't have come in. We're dealing with what do we do with testimony that shouldn't have come in now?
I would submit that it's not, what's objected to on appeal is simply not preserved, based on what was objected to at the trial level. But even ignoring hearsay for the preservation issue, there were 2 guns found in a wardrobe. Defendant's license, his work ID, his pill bottles, his mail was
The
found.
license had a different address on it though, correct?
It may have been Strathmore,
Yep,
which is
his
what he
other
had
place where he lived.
rented, but he owned this house and he rented it to his wife. That
Right,
came out.
and it goes back to the video too, where he calls the police and says, my house is burglarized.
Correct.
And he's showing around and has the keys.
The 2018 video, he says, my house is burglarized. He points to the house. He then goes into the house. He opens a bunch of doors. He goes to the attic. He says, I'm renovating my attic. He says, these are all my belongings. Then he goes to to the enclosed porch and says, all of this is my belongings, then is
So you're leading to a harmless
essentially
error analysis. And it does seem on the surface, a lot of evidence against this guy, but on the other hand, he was acquitted with the same evidence at the first trial of possessing one gun in that same house, and the jury was hung on the other two guns. Hard to say proof of guilt is overwhelming when the same proof and more at the first trial didn't yield a conviction.
Well, I would submit that it's, generally we don't try to assume why a jury did what it did on the first trial, and in the second trial, there was different proof. And I guess that leads into the ineffective assistance and specifically why there wasn't a missing witness instruction request. And what I would submit is that if that happened and it was successful, the people could have reopened the case and called Ms. Kamel, and she could have testified that he shot at me, which would provide proof of not only constructive possession, but actual possession. I would submit that based on the proof that we have here in the trial that matters, the second one, we have overwhelming evidence.
What about ineffective assistance of counsel for, if you're right that counsel failed to preserve the hearsay from Ms. Camel, what about defendant's argument that that was ineffective? What possible strategic reason could there have been not to object to that hearsay testimony?
I think there was other evidence of the same statement. So say it got in that she had been shot at. There was fragments of a bullet inside the car that was established by testimony from another RPD officer, and that matched, or it actually came from the gun, the Ruger, that was found in the wardrobe. So it's cumulative. I don't think it would have changed the outcome.
Gotcha.
The fact that she was married to defendant, or that she had some romantic relationship with defendant, was established by the same 2018 video from the then officer, now investigator. So all of these statements are either innocuous, they don't really incriminate defendant, or they're established by other evidence. So I would submit that there was a strategic reason not to burden the court with, preserving that argument that's now made on appeal.
You wish to rest on your brief on the way to the evidence issue?
Yes, Your Honor.
Thank you.
Thank you.
Case 865, People versus Eric Williams. Reardon, good morning.
Morning, Your Honors. Kathy Reardon on behalf of Eric Williams. I'd like to focus my arguments on points 1B and C and point 2 this morning. 1B addresses MRTA. We're asking this court pursuant to 2205 sub 3 to apply that section, the probable cause provision, to this particular case, which is a pre-enactment and pre-enactment search and a post-enactment hearing.
This is the scenario suggested by Judge Halligan in her footnote in the Court of Appeals case, Pastrana.
Correct.
I believe. But as a threshold issue, doesn't appear that that contention was raised below and is thus unpreserved. Did I miss something there?
No, that's correct. It was not raised below. It wasn't preserved by trial counsel there. We've addressed that in 1C for the IAC suggestion that, there was no basis, there was no legitimate strategic explanation not to at least raise it. The DA had actually raised the issue during her summation. I think most defense counsel, at least, were very aware that this was coming down the pike. And this happened 6 weeks prior to enactment was the date of the incident, and the hearing occurred 10 months after. So
We have People v. Martin, the people reference in their brief, the third department case, 3-2 case. I don't know if you've seen People v. Fasoli.
I have.
Okay, now that one sent essentially in Martin.
Correct.
tell us review that. Why should we not follow what the second department did at Facility?
So in terms of Martin, and I'm sure the court is aware, that case has been accepted and that's going up to the Court of Appeals. Defense counsel, who is actually going to be filing his responding brief, I think that's due December 1st. So it should be heard sometime in the spring. Essentially, I think what Martin is saying, in which we would agree with, is that sub 3A is directed to at the present evidentiary findings of the court. It's not changing the conduct below. It's simply addressing what happens at the time of the hearing. And we submit that's really what should be followed, as opposed to Fasoli, which does follow the dissent in Martin. Again, it only addresses the court's fact-finding authority at the time of the hearing and not the conduct that occurred below. And really, MRTA did a couple of things. It dealt with or corrected harmful convictions in the past that were below what really needed to be addressed in terms of an enhancement, allowing them to expunge records, seal records. It also prevented future conduct where the legislature believed that some of these things didn't need to be charged as they were charged. So that kind of leaves the people who were sort of pre-enactment but post-hearing sort of in a black hole here. And so we submit that as a result, that section 3A should be read to address present what's happening during the hearing, but just taking a look back at what the conduct was. And certainly here, the only basis for this search was the marijuana, was the fact that the driver held up a blunt and that they saw something that looked like marijuana that could have been in some sort of packaging. I think they referred to it as some out of state packaging or something to that effect.
Look, I think you make some good arguments that if MRTA applies to this case, your client wins. It's just the question of, is it retroactive to the hearing? We know from Pastrana, Judge Troutman's opinion there. She says it doesn't apply to, and all 7 signed on to this, by the way. MRTA doesn't apply retroactively to searches that took place before the effective date of the statute. So this search took place before the effective date of the statute. Martin seized on to Judge Halligan's footnote in a dissent. She agreed with that principle I just said, but she said it might be a closer call if the suppression hearing was had after the effective date.
Yes.
But none of the other Court of Appeals judges signed on with that question. It might be closer. Not Judge Wilson, not Judge Rivera, nobody else.
They did not.
So can we read that as they don't have any concerns with this Judge Halligan scenario? They don't think, they say it plainly, the statute doesn't apply retroactive if the search took place before. How do we get around that here?
I granted they didn't sign on to it, but again, that was a different case because everything had occurred prior to the date that MRTA had been enacted. I think that it was an issue simply because it wasn't raised at that point. It hadn't come to anybody's attention other than Fasoli and Martin. I haven't seen this issue raised in any other of the jurisdictions. So.
Right. Well, if it's unpreserved, then we have to reach it under IAC.
Correct.
And for IAC, let's say we agreed with Martin, the majority of Martin. For a single error such as this to rise to the level of ineffectiveness as the counsel, it has to be a clear-cut and dispositive error, right? Clear-cut winner. And the case law go on to say that if the contention is based on novel legal theories where there's no appellate authority, then it doesn't constitute one of these single errors that justifies a reversal. At the time of the suppression hearing, when the argument should have been made, Martin wasn't decided. There was no appellate authority anywhere supporting your client's position here. the only authority came after you filed your initial brief.
Correct, that's correct.
So if the people say you can't, how can we fault the defense lawyer for not making this novel argument when it hadn't been recognized in any court of law to that point?
And I understand that, but again, I submit that this was widely known that this was coming. I mean, this didn't happen just, the month or 2 months before all of this occurred. This was legislation that has been addressed for years and years, and finally was brought forth and ended up in 222 and MRTA. So I think defense counsel had an obligation to be aware of this. And the fact that the DA raised it in the summation and counsel didn't jump on that at that point and say, wait a second, maybe this is something I should be paying attention to. I think that maybe addresses the court's question as to how we get to that point.
So you want us to pick between the third and the second department on this?
I'd prefer that you went with the third.
Yes. Figured you might.
Yeah. And I'd just briefly like to address point 2, which may or may not really have any relationship to this once, depending on how the court decides my prior argument. But clearly, I think Mr. William invoked his right to remain silent. He said, I got nothing to talk about, just want to go to jail, want to go to sleep. I think it was clear that he was done talking with the police at that point. And Officer Bauer's response was, I'm not going to waste your time if you don't want to talk about anything, but I'm just curious about the fight. So I don't think he could have made it any clearer. Granted, it wasn't Lipton. He didn't say it 6 times over, but I submit that he didn't have to, because he made it clear he didn't want to talk and he simply didn't want to be there. And I think because he had already invoked his right at that point, it wasn't scrupulously honored, and that would be sufficient to suppress the statement. Again, it kind of goes back to my other argument, but at this point, that's what we would request. Sorry, I'm losing my voice. The court has no further questions?
That would result in suppressions of any, was he made that, he invoked rather soon. Matter of fact,
He invoked immediately after.
we have so many of these cases, but similar facts, but if my recollection is correct, the officer who was one involved in the stop said, do you advise him of the rights? Said, do you wish to waive them? He never actually said yes.
No.
Never answered yes, but he just said, just take me to jail. I don't want to talk, blah, blah, blah.
Correct.
I mean, an argument could be made separate and aside from he unequivocally invoked the right to remain silent. He never actually waived them. You're supposed to say yes to that question, right?
That's correct.
He never got to yes.
He didn't, and he affirmed that he wasn't going to speak, I mean, pretty clearly to the officer. And this is almost as if that situation where the officer doesn't or pretends not to hear what this individual had just told her.
This is all on videotape.
I'm sorry?
This is all on videotape.
It's
for
all on video. It's,
all of us.
I think 25 minutes into
Yeah.
the tape.
Thank you.
Okay.
May it please the court, Bridget Field on behalf of the people, and I would like this court to follow the second department on the first issue. Pistrina says that Marta is not retroactive. Martin is up in the Court of Appeals, so.
Well, just to be clear, we don't necessarily have to choose between the second and third. We can say the lawyer was not ineffective because at the time there was no authority supporting that position.
I absolutely agree in the fact that we're arguing about that now, the standing of the law now, it's not even clear today as we're standing here. There is no fourth department case on this issue. So to say that counsel was ineffective for failing to raise an issue that is just developing at this time and just coming up through different departments of the appellate division, the first department hasn't ruled yet, and this department hasn't ruled yet. I don't think that this was a clear-cut error on the part of defense counsel for failing to raise an issue that didn't know how appellate review was going to go of the issue. So if this court finds that it was an ineffective assistance of counsel, then this court doesn't have to address or would not address the actual finding of this pre-enactment stop, post-enactment hearing case.
How about the Miranda issue? Was there a waiver to begin with? And then if so, was there an unequivocal request to terminate the question?
So the interview has been provided to the court. I did not watch it last night, so I believe that counsel is correct that defendant did not answer, like his answer was, or that his answer was, I want to go to jail, but I just don't recall off the top of my head right now. I think that the court has to look at the totality of the circumstances, and this happened immediately. Defendant indicated that he wanted to go to jail, but Officer Bowers immediately said, I just want to talk about this fight, a fight that happened earlier in the day. He was arrested, a car stop based on the smell of marijuana, and patted down, and they found a gun. So the stop wasn't related to any fight, had nothing to do with the fight. I believe
Right,
that
well,
there
let
was.
me refresh your recollection on what the defendant said on the video. The Officer Bauer asked, you want to waive these rights? That was just explained to you. To which the defendant responds, I ain't got nothing to talk about. I just want to go to jail. I want to go to sleep. Bauer says, well, I don't want to waste your time, but I'm curious about this fight. And that seemed to be like blowing right through a red light there, at least a deep yellow one, without ascertaining that he wished to waive. That's how it looks. Now we do have case law. If you look at, I'm sure you have, what's an unequivocal assertion, unequivocal invocation of the right to remain silent. You can find cases to support either side on this. Here, though, we have the added problem of maybe there wasn't a waiver to begin with.
I would argue that this court has to look at the totality of the circumstances and the cases that speak to what an unequivocal invocation of his right was. This was the first time he didn't say, I don't want to speak. He said, I don't have anything to say, not I don't want to speak to you. And there is a difference. This is unlike Lipton, People v. Lipton, that this court decided earlier this year, not in my favor, where the defendant had mentioned 7 times that she was done talking. Here, he didn't say he was done talking. He said he just didn't have anything to say. There's definitely a distinction in the words that the defendant used in this case, and that this is a totality of the circumstance case, because this wasn't, he didn't think about whether he wanted to continue talking. This was all immediate. There was no break. Officer Bauer didn't leave. This was a very, honestly, very short interaction within the beginning of when she came in to speak with him. So there was no, left the room and came back and started asking questions again, or took any kind of pause or anything else. The defendant immediately engaged with Officer Bowers without
This
saying another.
entire crime was captured on surveillance video. We saw him with a gun. We saw where are you relying on a harmless error in the alternative?
Yeah, yes, Your Honor. He, in this case, defendant was arrested. It was a traffic stop. He was taken out of the car after the smell. Well, the driver had blunt. There was packaging that they did describe as out-of-state marijuana bags, or bags known for selling marijuana, and a pat down was conducted of the defendant. The gun was found on his person. So his statements as to that he, in the statement, ultimately in the conversation, he talks about a fight that apparently happened earlier in the day. And the defendant says something to the effect of, "That's why I had the gun." So that's apparently what led to him going to get the gun. I don't know. I have no idea why the officer asked about the fight. That none of that is in the record, but a gun found on defendant's person, his statement that I had a gun is
But don't we
harmless.
have to give him an opportunity to decide whether or not he wants to plead guilty if the statements are suppressed? I mean, because if we send it back, if we decide that he didn't,
Potentially if, and I would say it's if we
Yeah.
first have to get past
murder.
murder, we have to get past the the claim of ineffective assistance of counsel, which I argue there was no ineffective assistance of
We
counsel
don't have
here.
we don't have to get by murder to suppress the statements.
That's true.
I thought Judge King had been talking about the statements.
But the statements,
Look, if this were a trial, maybe harmless. Plea, and we have a case for Court of Appeals recently from this court, which makes it clear it's exceedingly rare to have a harmless error on a plea, unless the defendant explains why he's pleading, which is rarely the case. But anyway, we'll take a look at all that. Anything last words you wish to add?
no, but absolutely, if in fact this court would find that that the court erred in suppressing his statements, this would need to be remanded for further proceedings. This isn't a situation where the statements that he possessed the gun was the only evidence. There certainly is sufficient evidence given that the gun was found on his person. So this would be an issue that would need to be remanded for
We
further
understand, yeah, it
proceedings.
might not help him much in the long run. Yeah.
Correct.
Yeah.
Thank you.
All right, thank you. Case number 867, matter of Christina Dees versus Ronald Contreras, 867.
God bless it.
Bless you.
Morning, Your Honors.
Good morning. Let's wait for counsel. He is there. We are ready to proceed.
Thank you.
Mr. Degnan.
Thank you. May it please the court, Your Honors. I'm Brian Degnan. I represent Ms. Dees. I'd like the court to know that Ms. Dees is in the waiting room. She's been an active participant in this appeal process. Your Honors, case was an initial custody determination on Monroe County Family Court by referee Bailey. My client, a couple of points they're interwoven, because the first point I'd like to make is that the record reflects a lack of sound and substantial basis. And then there was a procedural error made by the court in Monroe County Family Court. Both the mother and father filed dueling family offense petitions and then cross custody petitions. Throughout the trial, it was made known that my client moved to Pennsylvania in approximately October of 2023, while New York was exercising jurisdiction.
With the child?
With the child, that is correct. And the parties were separated at that point. Mr. Contreras had very little to do with the pregnancy, and the parties were not living together after this child was born. He had virtually nothing to do with this child, didn't know the child's pediatrician, never testified to the child's date of birth. There was what I attribute significant domestic violence, both of my client at the hands of Mr. Contreras, that is completely devoid in the record. The court ignored domestic relations law and case law on this issue in its analysis. There wasn't even a superficial analysis as to the physical violence that occurred.
I thought the allegation from the mother with respect to the family offense petition and the reason why she believed the father should have no contact essentially with his kid is that the father placed one of her 9 cats in the toilet.
That's correct, Your Honor. And
there was a toilet. I mean, look, I have consistently been against putting cats in toilets and don't condone that. But this wasn't, you put the kid in the toilet.
That's correct, Your Honor. I would agree with that assessment, but as I said in my brief, Bella's law that is still kicking around in the assembly is that the research has shown that an individual who harms an animal is substantially more likely to harm a human.
Was the cat, he didn't flush the cat down the toilet.
Well, I believe the testimony referred that he was baiting the cat. I'm not
Right,
too
cat-
familiar.
Please.
I don't know, Judge, but I'm not really familiar with an individual giving an animal, let alone a human, a bath in a toilet. It's kind of repulsive and makes me gag here this morning, just thinking about that. And then having those animals in the house. But the court said that that wasn't credible. The father, his testimony just said, I didn't do it. And so we have an issue.
I think he might have said he put him in a tub. I'm not sure the shower. I'm not sure the cat appreciated that either.
But then we had a second incident where he was harming a cat, where Ms. Dees heard him in the basement. There was loud noises. She physically observed the father come up with scratches, and then he was silent when he should have said something in terms of what was going on down there. But the record is devoid of the physical violence that went on. There was an incident where Contreras was alleged to have kicked my client in the stomach. I believe she was pregnant at that time. He choked her and he hit her in the head 2 separate times. The court's decision doesn't even go through an analysis as how it considered it domestic violence. It simply says that the court considered domestic violence. And that is what is tantamount to a superficial analysis. It means absolutely nothing.
Well, the court said she didn't believe the mother.
As to the animal cruelty, that's correct. It did not.
I just thought, okay, maybe I thought like general credibility issues and so forth, but.
So the court missed the analysis of the actual physical violence. I think we're in a different situation had the court said that they've observed the testimony of both the petitioner and respondent as terms of the physical violence, and then they didn't deem my client credible. The record is completely silent on that as the decision. So during the proceedings, towards the end of the trial, Dad had visitation. He was going to Pennsylvania to visit the child. Mom then in Pennsylvania filed for what is referred to as a family offense petition, or I believe the testimony was a PPO in Pennsylvania, which then limited the visitation to being supervised. So we had dueling orders in New York State and Pennsylvania. And this is the point that was in point 3, is that the court then violated the UCC JEA in not conducting a conference on the record or making the transcript available to counsel. It's as if it never happened. And the court in its decision and order, just like to read it, quote, said this court was then forced to conference the matter with the Pennsylvania Court of Common Pleas, Judge Piniella, who agreed to modify his order to allow father's visitation. It is in complete violation of DRL 75I that requires substantive matters to be done on the record, affording the litigants an opportunity to be heard and to participate. It also flies in contradiction of this statute that the record was never made available. We don't know what was said or done during that conference, or let alone whether that conference occurred. So it's very troubling. With today's political climate, due process it's an important issue. And my client and Mr. Contreras were deprived of due process. I don't know what Mr. Contreras would have said. Maybe he would have wanted the case heard in Pennsylvania. I don't know.
Did your client object at all? Did your client knew that she was talking to the Pennsylvania court? Did your client object at all to that fact?
I don't know. I don't believe so, Judge, that this was rendered in the decision that this court was required to conference with Pennsylvania. I don't believe she was notified that there was communication between the two courts.
But didn't the judge tell the parties that she was going to talk to the Pennsylvania court?
She did.
And did your client express an objection or indicate that he wanted to be heard at that time?
Your Honor, I represent Ms. Dees. She's the mother in this case. She did not. And it's my position that the court has the obligation to notify the parties that they have the right to present evidence, right to be heard. And my client and Mr. Contreras were deprived of those rights.
When we get back to the evidence here, it does seem concerning. Perhaps you would disagree that the mother didn't want to recognize the father's role as biological father and had the child referred to a convicted murderer who's incarcerated in prison as her father instead. That evidence did come in, did it not?
It did, Judge, and that was the argument I made on that evidence. If you're familiar with the movie Minority Report, that it's not pre-crime, that these were statements that were admitted. I made the evidentiary argument that it was irrelevant evidence. It was not properly authenticated in my brief. These were statements she made before the child was even born. These parties were not married. Paternity wasn't established. So from a legal standpoint, we don't know who the child's father was. The child was in utero.
You're saying she didn't make these statements that this incarcerated individual, after the child was born, didn't say to the child, that's your father over here in prison. And this guy over here who's wanting to visit with you is not your father? That didn't happen?
That did not happen.
Okay.
The statements that she referred to as the convicted murderer being the child's father occurred before the child was even born. And it was on a social media platform, Your Honor. So my client, while exercising her right to freedom of speech, certainly it was used against her, but it was unlawfully admitted. It's irrelevant, quite frankly, as were all the TikTok videos. It's somebody posted on social media. I could go on social media today and say I'm the general manager of the Blue Jays. What does it mean? It doesn't mean much.
Means you're doing a good job.
It does. It does. And thankfully the game didn't go late last night. So, and the last point I'd like to make, Your Honor, is the court did mention that my client attempted to submit post-proof documentations, emails, and that was in the court's decision. And then the court went on to say that they didn't consider this. Obviously, the court knew about it, and it begs the question, why wasn't a conference scheduled by Monroe County Family Court to have counsel come in, give them the opportunity to reopen the proof? Again, my client is being harmed here, not only by the court. Now, mentioning this, there's no record in the decision whatsoever about this evidence. And then we also believe that it's possibly ineffective assistance of counsel, her trial counsel, not to do something with this incident.
All right. Well, thank you very much.
Thank you, Your Honor.
for your argument. Proceed to Mr. Salvedo.
Salcedo, can you all hear me?
Thank you.
Thank you. And may it please the court. I made a few points here. I'd like to say, Justice Lindley, you're right that it is concerning that the mother in this case was more willing to foster a relationship between the child and Mr. Batts, who was serving a very long sentence in prison for murder. She's more willing to foster that relationship than the relationship between my client, the biological father of the child, who, by the way, she admitted at trial under oath that my client is the father, so there can be no dispute about who the actual father is.
Were these attempts to establish a relationship between the convicted murderer and the child, were they ongoing after the child's birth, or was it just pre-birth, as counsel had just indicated?
They were ongoing after the child's birth, and in fact, the mother testified that the child had phone contact with this person, Mr. Batts, every single day. Whereas at the same time, the family court had ordered that my client, the actual father, would have phone and video conference communication with the child. And she, the mother, unilaterally canceled those phone calls because she thought my client wasn't interacting enough. So we have her on the phone with Mr. Batts and the child every day, but she won't even follow a court order that gives the actual father the right to speak with his one-year-old child. So I do agree, Your Honor, that is concerning. And to me, that's the most important factor in this case, is that as I've set forth in my brief, where one of the parents intentionally stifles the other parent's visitation, there is a strong probability that arises that that interfering parent is not an appropriate custodian. And that happened from start to finish in this case. It's hard to imagine a more egregious situation given that the mother violated multiple court orders, the one I just described about the phone contact, but also my client was given the right through a temporary order to visit this child in person in Pennsylvania. The mother declined, refused to meet my client halfway. She was in Pennsylvania at the time. My client was in Rochester. She refused to meet him halfway for the visits, but my client said, you know what? I'll drive 4.5 hours to Rochester, to Pennsylvania to see my child. The mother was not supposed to be there under the court order. He drove all the way and the mother did not leave that first in-person meeting. And then there was a later in-person meeting. He drove all the way over there and the mother said, well, I'm not going to produce the child. Why not? Because in the meantime, she had gone to a Pennsylvania court and gotten a restraining order that conflicted with the visitation order from the Monroe County Family Court. I think that was completely inappropriate. And my client ended up driving 9 hours round trip without being able to see his daughter. So I think that is the most important factor in the analysis, and it's quite clear that she stifled his visitation, including, as I say, by violating court orders. I do want to point out that she violated the very order that's on appeal here. The order says that she was to immediately relinquish the child to my client, and instead of doing that, my client had to get counsel in Pennsylvania to get an order from the Pennsylvania court to eventually obtain custody of the child. That took nearly a month. So I think these are egregious circumstances, and what this court is looking for is a sound and substantial basis in the record to find that my client should receive custody, and I think that all by itself is enough. I also want to point out the financial and housing situations of the parents. The mother testified she was broke. She was evicted from her apartment in Rochester. She moved to Pennsylvania, was in eviction proceedings in Pennsylvania, both times for non-payment of rent, whereas my client has a steady job, has a 2-bedroom apartment that he lives in by himself. And so the child is in a much better situation with my client for those reasons as well.
Did I read the record correctly that when the mother was in New York in a 1-bedroom apartment, there were 2 dogs, 9 cats, and 3 humans?
I believe so. There were many cats. I don't know that we know the exact number, but it was 9 cats or 7.
The referee put the number at 9 felines. Look, I like cats as much as a nice guy, but we have a 1-bedroom apartment here, and the cats were, by the mother's admission, flea infested.
Yes,
that's not an irrelevant factor in determining. I assume the cats went with the mother, not your client.
I believe at least the vast majority of the pets went with the mother to Pennsylvania. They weren't my client's pets, and I think that does speak to what would the home environment be with the child if she were to have custody. And I don't think it's appropriate to have so many cats. There was also evidence that she wasn't cleaning the litter boxes, in addition to, as Your Honor mentioned, the fleas. And so I do think my client has a better home environment for this child. My friend on the other side mentioned allegations of my client harming the pets, and the family court reviewed those allegations and concluded that the mother simply was not credible. Apparently there was some video submitted that showed my client harming a cat. The family court said it reviewed the video and the video simply didn't show that. The mother admits she did not witness any sort of harming of a cat in the basement or any dunking of a cat into a toilet. She didn't see any of this. The family court was well within its bounds to conclude that she hadn't proven those allegations. Same with the domestic violence allegations. The court doesn't need to go through a thorough analysis of how DV affects a custody determination if the DV wasn't proven. And on page 9 of the record, this is in the referee's decision in order, the referee dismissed the family offense petition that the mother had filed. That was the petition that included the allegations of DV, and the referee dismissed it for lack of evidence. That's what the court said. So it's pretty clear that the court simply did not believe those allegations. The court obviously was there, unlike all of us. The court was there to watch all the witnesses, to judge their credibility, and I think this court should defer to that determination.
Thank you, counsel.
Thank you.
Mr. DePasquale.
Thank you, Your Honor. May it please the court, Andrew DePasquale, attorney for the child. Happy to answer any questions about the merits of the case, but I did want to give an update as to my client's current situation. So I did meet with her 2 days ago over video chat. I was able to speak with the father, Mr. Contreras. He showed me around the house. It does look like a a safe environment. It looks like a nice home. She looks like a happy, healthy 2-year-old. However, there is a current court case pending in the trial court. It's scheduled for this Friday. There is an active warrant out for Mr. Contreras. I did inform Mr. Contreras about this, and as well as Mr. Salcedo. So I believe at this
Do we
point,
know
he
the
is.
nature of the charges on the warrant?
I'm sorry, Judge?
Do we know the nature of the charges on the warrant?
There was I believe it was an emergency petition filed by Ms. Dees a while ago. And so it is in family court.
Not criminal charges.
It's not criminal charges.
These are family offense, perhaps filed by the mother, allegations of some type of assault, harassment, what have you?
No, the allegations are just that she hasn't seen my client.
That was
in a
gonna
very
be my
long.
question. Has mom seen the child? What is the visitation like?
It's been a very long
Access.
time. When I spoke with, I believe it's been since this case ended. When I spoke with the father, his statement was that she hadn't reached out to him. You know, she's entitled to supervised visitation. So he said that she hadn't set up what she was supposed to do. So, and then he also has.
You're in favor of her getting supervised visitations to reestablish a relationship?
Of course, yeah, and I do think there is a sound and substantial basis in the record for the referee's decision. I just think that this update is very important to give the court in light of my position.
Yeah, if you keep us apprised of their subsequent orders might render this moot before a decision comes out, that'd be appreciated.
Certainly. If there's any other questions, I'd be happy to take them.
Thank you.
Thank you.
It's 869, matter of Woodrow Abrams versus Smith. Greenberg.
Thank you, Your Honor. I am representing, or do we wait for Ms. Cavagnaro to come in?
We don't have anybody arguing but you.
Last I checked, she had not checked in.
I had her as a submitted.
Yeah. Oh, okay. In that case, I am representing Mr.
Feel free to follow suit if you wish to, but of course you came all this way. So
I
we're not
did.
going to stifle your
No, that's
right
okay.
to argue.
Well, I will be brief then. I am representing Mr. Woodrow Abrams, who's in the courtroom with me today on his appeal from an order that was entered on December 15th, 2023, which had granted him supervised visitation with the subject child, who is his daughter. He does not have custody of his daughter. The other side does have custody. The maternal grandmother has custody of the daughter. And that is, of course, not before us today. What is before us today is whether the family court of Erie County, Your Honors, correctly decided the issue of whether he should have supervised visitation. Because there are other, I mean, obviously, one of the challenges with family court when you appeal from the custody and visitation is that new petitions get filed and, you know, the facts kind of just move with the goalpost, if you will. But this decision, we believe, was wrong, though, just the four corners of this decision. I mean, supervised visitation, Your Honors, are relevant or appropriate in areas where there's been an allegation of abuse or neglect or some kind of alienation, and you need the supervisor to come in and supervise in order to patch the family back together again. My client was never alienated from Autumn, even with, I'm sorry, with the child. I apologize for using her name.
So
Yeah.
here's my question, which is one, which is he had only used 12 out of 52 visitation that prior to the court making the decision. So I think, I'm not sure if the court relied upon that aspect in doing supervision because there were issues on whether or not he was going to show.
I mean,
Correct?
I then is partially correct, I believe, but I also think that when you look at the visits that he did
Can you
have,
keep your voice up? I'm sorry.
when you look at the visits that he did have, they went well. They went
Yeah,
very
the child was happy to see him and
Yeah.
he was playful and
for all of the strife between the maternal grandmother and Mr. Abrams, she never reported to him the child coming back as being anything other than clean and unkempt and undamaged. And I mean, basically, even if that's true, even if that 12 days is correct, is that really enough to get it into I'll just play the devil. We'll say that was the reason why the 12 missing all those visits, and only got the 12. Is that enough to put it over the burden, meet the burden that's required for, I think, supervised visitation? I mean,
Mr. Greenberg.
yes,
Order of supervised visitation was from November 21st of 2023.
yes,
So we're coming up on 2 years now.
right.
Has there been progress toward unsupervised visitation since you filed the brief?
Well, what's happened since, Your Honor, is that, well, since I filed the brief or Ms.
Since this
Yeah.
order, in other words,
Yeah.
are we still in the status quo of him having supervised visits?
Well, he still has the supervised visits, but the status quo never really is I always point out with family court cases, the status quo is never cemented in stone, like when you're appealing from a criminal conviction or a TPR. What's happened since, Your Honor, is that he's gone to Angel's visits, the Angels, I don't know if I'm getting that correctly. Well, the Angels supervised visit. Angels Monitoring Supervised Visitation Program is the full name. And he's getting glowing reports from that. I mean, he used that as a basis for filing a new round of petitions in family court.
He did file a new petition?
Yes,
And that's pending now?
yes.
And where are we in that proceeding?
I think it just got filed. So I think it's very
Well,
early.
he filed a new petition saying, look, I've been doing great here, was supervised, can I get unsupervised?
Yes. And he might even be in for custody as well, because he is the paternal, he's the father.
So he may get some relief. He's got two avenues of relief, this
That's
appeal
right.
and one modification
Yeah,
petition.
so you can certainly look at the facts that I've given you and decide accordingly, or you could revert.
I understand.
Yeah, yeah. So, and as far as the allegation of bizarre behavior, I mean, it's like, does bizarre rise to the level of endangerment? I mean, if I heard the previous case correctly, I heard about cats going in. I mean, that's pretty bizarre. I mean, but is that rising to the level of, was the
Refer
child
to
endangered
the-
by it?
Cat in the toilet incident?
Yeah, the previous case. Did I hear you correctly when I heard that?
I'm sorry?
Did I hear that correctly?
Yeah, there was an allegation of a cat being dunked into a
Well,
toilet.
that certainly has not happened in this case. I mean, I don't think there are any
No
animals.
cats in the toilet here?
No.
There correct me if I'm wrong, something about another TPR, another child. Is that still ongoing or no?
No, I'm so happy you asked me that question
Okay.
because that has been completely dismissed. And when that was now pending before a different judge, because Judge Cesar retired, and when the new judge, I believe it was Judge Filbert, got that case, he actually regained custody of that son. So that's no longer even pending. So I mean, that's why when I always said the goalposts always move.
Right.
And he's
Why you have custody of one child and you have supervised visits with the other one?
that is correct. That's exactly what I was thinking.
Okay.
Yes.
Wasn't he also accused of disparaging the mother of the child in this case and the grandmother of the child? Didn't that also go into play as to why Judge Cesar ordered the supervised visitation?
That could have been a factor as well, but the disparagement went in both directions. I mean, the maternal grandmother accused my client of being a crackhead and a drug dealer. So I think that maybe, nobody should be disparaging anybody. So I mean, if there was disparagement, I'm not going to say it didn't happen. It could very well have happened. And Judge Cesar, certainly you can take that into account. But then the question becomes, Your Honor, does disparagement rise to the level of requiring a supervisor? I mean, if disparagement did not affect the child.
But he was also talking to the child about the proceedings themselves and suggesting that the child should come and live with him. And that does create some emotional stress for the child. Didn't that also go into play with Judge Cesar when she made her decision?
That could have got into play as well, but my client denied ever discussing the cases with the daughter, though. So I mean, if that was a fact in the record, he would dispute that as happening. But certainly, you can always, as a general principle, take into account parental or in this case, grandparental alienation. But my client would dispute that whatever insults may have occurred between the adults, that he never discussed that with the daughter, that's the subject child in this matter.
All right, well, Mr. Greenberg, we appreciate your argument today and we'll review your brief carefully.
Yes, thank you, Your Honor.
Thank you. Case number 871 is Courthouse versus State of New York. Ms. Jones, you may proceed.
Thank you. May it please the court, Nicole Jones, appearing on behalf of Appellates. A brief summary of the facts of the action. This was commenced by Philip and Tammy Curtis as a result of an injury accident occurring on January 15th, 2021. Appellants appear now before you appealing an order granting summary judgment in favor of appellee. It is applicant's contention that the lower court erred in granting summary judgment. It is further contended that the Court of Claims does maintain jurisdiction over this claim as it is against the state of New York and Trooper Chad Berry as a matter of law under the Court of Claims Act, Section 9, subsection 2, as Trooper Berry was operating within the scope of his duties as a New York State Trooper. Appellants also contend that the lower court erred in granting appellee's motion for summary judgment on the issue of the standard of recklessness applied to the conduct of Trooper Berry. Applicant respectfully maintains the position that there are a minimum of 2 questions of fact which need to be presented to the jury. The first being which standard of negligence would apply to the case at bar. And it's appellant's contention that the trooper at issue, Trooper Berry, was not involved in an emergency operation, which would be covered under VTL section 1104, subsections A, B, and E. So basically VTL section 1104 provides enumerated privileges and actions that emergency responders are protected for performing. And it's further noted that under VTL 1104E, that if the conduct causing the accident results in injuries and damages, that it's and is not privileged under 1104 A and B, that a standard for determining civil liability would be ordinary negligence.
Ms. Jones, to break it down, I think your first argument is that Trooper Berry was not engaged in emergency operation because he was investigating a vehicle without an inspection sticker. And that's not serious offense. It's not an emergency. No need to take all these risks to go track down a guy whose inspection might have expired.
That is correct, Your Honor, yes.
Do you have any case law that says that it's the severity of the offense that determines whether the officer is engaged in an emergency operation? Because we have some cases that deal with some pretty minor offenses out there.
Yes, and I think that that's an important question that's really covered by Campbell v. Elmira, and which is cited in my brief. Basically what it's saying is that these laws that are protecting emergency responders were intended to accommodate the realities of dangerous conditions encountered by officers as they perform their duties. It is also intended to protect innocent victims and the general public by expressly not relieving emergency operators and their employers of all reasonable care. So in my opinion, it is a balancing test that is required. It's not necessarily just the action that, or just the complaint, or just the call that an officer might be responding to, but a totality of the circumstances. Essentially,
but Campbell comes into play if you're already looking at the reckless disregard standard. And you're suggesting we don't even get there. We shouldn't even get to Campbell and the reckless disregard standard because this falls out of Vehicle and Traffic Law 1104B.
Right.
I have a question about the Kabir case. And you cited, I don't know, 4 or 5 times in your brief, but in Kabir, we have this parenthetical after they explain the 4 categories in the Vehicle and Traffic Law section 1104. We have the statement. It's not a parenthetical. Is the privileges correspond generally with the articles in Title 7 of the Vehicle and Traffic Law entitled Rules of the Road. This is right from Kabir. And then the parenthetical, they give specific articles of the V&T law that they're talking about. And they included Article 25, the sections of Article 25, driving on the right side of the roadway, overtaking and passing. And I noticed that within Article 25, we have 1128A, vehicles should be driven as nearly as practicable, entirely within a single lane, shall not be moved from such lane until the driver has first ascertained such movement can be made safely. And it seems to me we have a situation here where the trooper didn't ascertain that he could cut out of his lane, cross the double yellow to make that U-turn. that's the error that the plaintiff is claiming here, which looks to me to be a violation of 1128A. And then we go back to Kabir, and that's privileged. So I want to ask you, did I make a mistake in that analysis?
No, Your Honor, I don't think you made a mistake in that analysis, but I think what this case requires is an extrapolation of Kabir. So Kabir also elucidates under VTL 1104B 4 specific movements that offer the emergency responder the privilege of protection against civil liability and also, a ticket for perhaps running a red light or making an illegal turn. I think in this case, what we have is not only the allegation that the officer failed to see what he should have saw, but that he failed to do quite a few things that would have amounted independently to a momentary lapse in judgment, which is what the lower court had decided the entire case was. Here, though, however, I feel he took a few steps, pulling to the shoulder, then making the turn, following into the lane of traffic. I think it seems contrite, but it is important to note that in this area, there is no signage delineating that a U-turn is illegal. And so my contention is that under the subsection 4 of 1104B, that would be the closest we get to what happened here, what the actual fact pattern is, but that the trooper did not need to break the law or disregard a rule of the road in order to make the maneuver he did, because there was quite simply nothing prohibiting him from making that U-turn, which is when the accident happened.
Would you say that if these were two civilians and the police came upon the scene and got all the facts and had a video of it, would the offending driver here, the trooper, be subject to a traffic ticket for violating the VNT law? I mean, failure to yield the way, wasn't there a failure here to yield the right of way? He turned right into the vehicle, right?
You could, yes, definitely argue that there was a failure here to yield the right of way. However, yielding the right of way, I'm not sure, Your Honor, if that would expressly fall under 1104B as one of the very enumerated rules that offer, or I'm sorry, enumerated situations that offer protection. And
right, if it comes in anything, it's for regulations governing directions of movement and turning. But we do have two cases that I'm sure you've seen. Maybe they were wrongly decided. I was on them. So there's a presumption they're probably wrong. But Flood and Dodds, have you seen those?
Yes, Your Honor.
Those are U-turn cases?
They are.
And we've said that that's protected activity under 1104?
I think the court has held that those are protected activity under 1104, but I would ask this court to consider all of the relevant factors to this actual U-turn movement. I think the issue here is that not only did the officer have an obstructed view of the oncoming lane of traffic, but did not activate lights and sirens to warn. And also, we're really unclear as to whether he was even executing an emergency operation at all. And I think when we try to take this case outside of his being a trooper, we are kind of construing the facts a little bit outside of what we're looking at. Here, we really have to get to step one, which would be, is this even an emergency operation? And I don't think it is.
Good.
Is there a challenge as to whether the officer was being honest when he said, I saw somebody with an expired inspection sticker and I was going to follow that person? Has that been controverted at all? Is there any evidence that there was no such car, or that the car, that it was made up or something?
No, Your Honor, I don't think it's necessarily a contention that the trooper was dishonest. We do have security camera footage that does show a car that is pulling out of the exit there. However, he himself testified that he was unsure if it was a missing registration, an expired registration. He couldn't tell me very much about the car itself that he was pursuing or intending to pursue, as it is alleged here by appellants. So I think to answer your question, no, I don't think we're questioning his honesty. I think he was unsure of what that driver was doing. And so I don't think that we can go so far as to allow him that emergency operation, because that kind of, it gives so much latitude to officers responding, then essentially gives us the question, what isn't an emergency operation?
Ms. Jones, I'm going to take you back a few minutes to a question that was posed by Justice Nowak. And you'd really have to be a devotee of our court to know this, but on September 16th of this year, and I suspect the Attorney General's office knows this because they were involved at that time, we had a case called Dill versus State of New York, where we affirmed in an entry. Very, very similar fact pattern. Flood, and I was on Flood, so that presumption goes all the more for me. and Dodds. But there, in that case with Dill versus State of New York, I think it was Justice Lindley and I and Justice Ogden were on the panel. We affirmed an entry with respect to the application of the exemption. But as I see, your argument here, I have to tell you, is very similar to the briefs in that case. So you're arguing that that the only thing the state is relying on here under B is sub 4, disregard regulations governing directions of movement or turning in unspecified directions. In that Dill case, in the briefs, as the record there is, it's available online, which show there the state also relied on 1143, which is entering a roadway. But in that case, in Dill, the trooper was coming, I believe it's the trooper coming off the shoulder.
In front of a gas station, I think, maybe.
In Dill?
I believe it was a gas station. I could be wrong.
This is the gas station, I think, this one, Your Honor.
Okay.
But I could be
Stand
wrong.
corrected.
We have that presumption going for both of us, so who knows? In any event.
It wasn't all credibility.
Ditto. So, but whatever. So there's entering a roadway. I don't know that entering a roadway is something, it's a regulation governing directions of movement or turning in specified directions. The Williams case upon which the state relies here was a left turn. That's, if you turn left in front of an oncoming vehicle, that's pretty clear. That's a violation of something. So there, the protection probably exists. But let me drill down what Justice Nowak was saying. I promise you, ultimately, this comes to a question. So do you think that what you cite in your bill of particulars and what Justice Nowak referred to for 1120A suffices for the state to say that is a regulation governing direction of movement? Or perhaps, again, following Justice Nowak's lead, when you look at Kabir and they say the 4 subsections of B sort of correspond to the titles within the rules of the road, you look, as Justice Presiding Lindley said, you would look at 1163A, where it says you cannot otherwise turn a vehicle from a direct course or move right or left upon a roadway unless and until such movement can be made with reasonable safety. So if we had to scratch outside the arguments of the parties, wouldn't that be a proper regulation for us to rely on to say that, yes, this U-turn is protected because that regulation I just cited governs directions of movement? Do you agree that we could find something in the rules of road to fit within B4?
I think, Your Honor, that if I'm correct as to what you're asking, I think what we would be doing is interpreting then what the direction of traffic, that's where these U-turns get difficult, right? Is because before the officer made his movement, he pulled to the right-hand shoulder. So he was, I believe, going eastbound. He sought to go the absolute opposite direction. So as he enters that opposite direction, he is pursuing in the direction that that roadway is traveling in. So technically, because this U-turn is not an illegal U-turn, he was proceeding within the rules of the road to proceed in the direction that he was going. And now your question as to whether the safety of the turn applies here, it does. And I would present to you that the officer in his testimony, the trooper rather, in his testimony did state that he thought it was safe to proceed. And further, had he saw the car, he would not have. And I think that's very telling because it is stating basically that, well, and he said it, that there were a million other tickets you could go after. This one wouldn't be the one that he would pull into traffic for. So because he because he proceeded into the roadway with a blocked view, however, it seems his testimony indicates that he thought it was safe. I think we have to go off of his perception of his turn, and he thought he was making a safe maneuver. Now, how much we can get into the thoughts of a driver during an accident, I'm not sure we want to go necessarily down that road, but I would point you to a few of the recent cases that were heard by the 4th Department that are not cited in the brief. Granite v. Monroe County in 2025 is one of them, and it looks like often the 4th Department has held that this standard applies when a police officer or first responder is actually responding to a call, which does differentiate, I believe, if I'm correct in my reading of the case that you were just referring to, those officers were responding to a call as they were in Williams v. City of Buffalo and Granite v. Monroe. All of them had a dispatch call, and in this case, there was not.
Thank you, Ms. Jones. We'll hear from the state now.
Thank you very much.
May it please the court, Sean Nix on behalf of the state. I'll start with the reckless disregard standard. The Court of Claims correctly applied the reckless disregard standard here because Trooper Berry's conduct was privileged under 1104B. Now,
Was there an emergency operation to begin with?
sure, I can address that there was.
Why is that? Because that's a threshold issue, right? Before we get to it.
Sure.
There's no emergency operation, game over.
There's no dispute that he was pursuing a traffic violator. And
For what?
for he claimed a missing inspection sticker, but it could have been expired as well.
Is that an emergency?
Well, whether or not it is under 114B of the VTL, which specifically states pursuing an actual.
Right, they define what emergencies are.
Yes.
Even though what it seemed to me or you like an emergency, the
Right.
legislature, they count.
In the Court of Appeals held in Cicerone, which we cited that whether or not the officer subjectively believed it was an emergency is irrelevant for purposes of 1104. So there was an emergency operation here.
So we had this administrative hearing and he was found that really what he did, the real problem with the maneuver was pulling over to the right a little bit and not, perhaps not even to the shoulder, but just enough within the lane to the right that he blocked his view. He blocked his view so that he couldn't see whether the oncoming car was coming or not. And the plaintiff's made an analogy here that the claimant rather, that's similar to what we have in Kabir, the glancing down, looking down as you're proceeding. And then, you have this sense of surprise. So this little mistake that's made, it's not really a violation of the rules of the road. You can make a U-turn there. The problem is this, like glancing down, and that's separate. And Kabir has said that's separate. Why shouldn't we agree with that?
Well, I think the problem with claimant's argument on this is that it narrows the application of 1104B4. 1104B4's language specifically references regulations that govern directions of movement or turning in specified direction, not simply those that prohibit them. The Williams case, a left-hand turn was allowed. It was the failure to yield to oncoming traffic that was the issue. Similarly here, the administrative investigation notes that he pulled onto the shoulder briefly, then proceeded into the roadway to make his U-turn. And the 1143, if you're about to enter or cross a roadway, at the very least, he crossed that roadway in making his U-turn. He must yield to oncoming traffic. So to hold that 1104B4 only applies when turning is specifically prohibited is just too narrow. And in the context of a U-turn, which is defined as turning to proceed in the opposite direction, 1143 specifically governs how you can make that turn because you cannot do so when there's oncoming traffic. So again, although like in Williams, although turning left, there was no evidence it was prohibited in that location. Doing so at that time, because as this court noted, failed to yield to oncoming traffic was a disregard of a regulation governing directions of movement or turning in specified directions. So I think the problem here is that claimant's argument is too narrowly defined. It would only disregard regulations prohibited only in areas where U-turns are prohibited. And certainly if there was a new U-turn, that's an easier case that would fall within 1104B4.
What if an officer is in a parking lot and gets a call, an emergency, backs out of the parking spot to respond, it doesn't look, there's an accident? Is that privileged under 1104B? And if so, where would that come in?
He stopped at a parking.
No, he was sitting there parked, gets a call, backs out. If you're at a store or whatever, you back out into the lane, doesn't look, and gets hit.
Well, it certainly wouldn't be a regulation governing directions of or turning in specified directions.
Yeah, so your argument is 4 is really broad. They want to narrow four, you want to make it really broad.
Well, no, our argument is really specifically with respect to U-turns. Because of the definition of U-turn, it will, 1143 will necessarily apply to U-turns. So we're not asking for a broad ruling on whether 1143 always applies to failure to yield cases. And a lot of them, blowing a stop sign. I think there was a case where officer stopped at a stop sign and then struck someone. There was a failure to yield there, but A specifically talks about stopping. So our proposal is that with respect to U-turn, 1143 will always apply.
Time out. What if you never, did you look at the definition of a roadway? Because 1143 pertains to entering upon a roadway. A roadway is the entire roadway. So it refers to me, at least, that you're entirely off the roadway when you enter it. That's not what happened here. So he wasn't entering a roadway here, correct?
Well, there's 2 points on that. He did enter the shoulder according to the administrative investigation. Whether or not the full car, and in the pictures in evidence seem to show him on the shoulder. So he did proceed off the shoulder and then entered into the roadway, but he was also crossing the roadway for a moment as the roadway is those boundary lines excluding the shoulder. To make a U-turn, you necessarily have to cross into another lane of the roadway.
If we conclude, contrary to your argument, that this was not entering a roadway, or that entering a roadway is not a regulation governing direction of movement or turning in specified direction, you would lose with respect to reckless disregard, correct?
Well, your honors pointed to other provisions in the VTL, 1120A, 1163A. And again, we've cited case law that don't necessarily cite specific regulations that have found that U-turns and abrupt left turns do disregard regulations governing.
It would be fair to say, though, that any U-turn that is made unsafely is a violation of a regulation governing directions of movement.
In the sense of failing to yield, correct. And I'd like to just, if there's any more questions on.
But it just seems that it's a narrow, and maybe it's the correct view, but it seems that if you have a situation where a person has a lapse in judgment, looks down, glances down like we had it here, if they're looking down, but they're not in the process of doing a turn, then it's negligence. But if they're in the process of doing a turn, exact same problem, glance down, momentary loss of judgment, but you happen to be doing a turn at the time, then that's reckless disregard. And that's where you would draw the line. Are they turning or are they not turning?
Well, again, because the language of 1104B4 specifically is somewhat broad, and that's regulations governing turning in specified directions. And as we note, 1143 fits within that regulation. And it's certainly not the case that the language only applies to prohibiting U-turns. It's whether or not they're governing U-turns. And there's case law from this court, the Second Department, and other courts that have found that U-turns, very similar U-turns, were privileged under 1104B4.
Thank you, counsel, for your argument. Is 872, matter of Daniel Hoffler versus Town of Pompeii Planning Board. Mr. Mancuso, good afternoon. We are joined by Mr. Ginsburg, who is remote. Mr. Ginsburg, can you hear us?
Yes, I can. I can hear you and see you, Your Honor. Thank you.
We may proceed then.
Thank you, Your Honor. May it please the court, John Mancuso for appellants. Seeker requires strict compliance. And the planning board in this case made several errors in the strict interpretation of the seeker procedures. Number one, misclassifying the proposed action in this case as an unlisted action when it clearly meets the thresholds for a type 1 action under seeker. And number two, it adopted an impermissible condition negative declaration, which cannot be used in a type 1 action. And even if you assume their classification was correct, they followed none of the procedural prerequisites in the regulations for usage of a CND.
Before you get to the merits of your secret violations, the procedural, could you address preservation?
Yes, Your
Mr.
Honor.
Ginsburg says you argued one thing below on both of your contentions, unlisted, and then the neg deck. You switched it, I believe, in your reply memorandum below, and you've abandoned the argument you made the first time in both instances. He says we don't even have authority to get to that. Do you want to be heard?
Yes, Your Honor. Several points on that. And I'll address each of the two arguments we've made principally on appeal separately because they do have different predicates in the record. With respect to the type 1 designation, the focal point below was a subparagraph of the secret regulations that dealt with the type of use, and they were arguing agricultural versus industrial as being the prerequisite for the classification. But the overarching concept of the regulation is the same subparagraph. We're talking about non-residential use and expansion of a non-residential facility by more than 50%. Then you go down to sub-regulations and you're looking at parking to then determine that.
Mr. Mancuso, just so I catch up to where you are, but my understanding is the petition relied upon B8, which has to do with non-agricultural use.
Yes.
In reply, B6 was advanced, and on appeal, you rely solely on B6.
We rely solely on B6 on appeal. B6 subparagraph 3 was cited in the petition. In 3637, they cited the general, paragraph, and then they drilled down further to use a further subparagraph to further lessen the threshold for a type 1 action. So in their rationale before the Supreme Court, they principally focused on the idea that a non-agricultural use in an agricultural district would reduce it by 25%.
So B6.3 was mentioned but not relied upon in the initial motion, and then I'm sorry, B8 was.
They took it one step farther than B6 subparagraph 3. They used B8 to further reduce the threshold. My point is you have to look at B3 in order to actually determine whether or not there's an expansion of the non-residential facility in the first instance. But I will also point the court, in addition to citing that section in the petition and in the initial memorandum of law on reply, they did further specify the precise argument that we are making on appeal that we are relying on, which is at 865 to 66 of the record, where they actually did articulate specifically that B6 provides that the expansion of existing non-residential facilities that exceed 50% of certain thresholds are deemed to be type 1 actions. They go on to explain the exact analysis that I am making on appeal.
Do we know whether the court entertained it? I mean, if it came up in reply, we don't have something where the court says, well, I'll entertain it, I'll accept a supplemental brief. Like sometimes we do that if we're gonna entertain something new as a Supreme Court judge. We don't know either way. We don't know whether the court just disregarded it, said it's in reply, I'm not gonna consider it.
The court did not address any of the threshold procedural arguments that were raised by petitioners, even the ones that they had made in the petition in their memorandum of law or the arguments I'm making on appeal. None of the procedural arguments were addressed at all in the decision. The only explanation given in the decision was substantive compliance with SECR, the hard look standard. So I cannot answer the question, Your Honor, as to what the court may or may not have considered, but there was no written analysis undertaken by the court on any of the threshold procedural requirements. So that the classification of the action was not addressed at all.
The difficulty is when you may have cited B6 somewhere, but clearly the argument, as I read it, was B8 below. And that was the debate that was engaged with by the respondent. So I think the point is that, wait a second, it wasn't preserved. You can't reach it because it's not preserved. And incidentally, it's awfully unfair because they didn't advance it in any obvious way or even apparent way. So that's really the issue, Mr. Mancuso, at least as far as I'm concerned, that I have to look at on that preservation.
I understand, Your Honor. And I will say that it was not advanced explicitly until reply. It was advanced explicitly on reply at 865 to 866 of the record, which is the reply memorandum of law. I will then further address, I'll address it now. It applies to both of the issues. equally, but notwithstanding the lack of it even being addressed below, let's just say it wasn't mentioned at all. And in both instances, really on reply, both of the arguments I'm relying on appeal were mentioned in their reply memorandum of law. I submit that it did not need to be raised at all. I think the exception to the general rule of preservation would be applicable under the circumstances where it is a pure and dispositive issue of law that is discernible on the record. These are two very, very focused.
Have you read
procedural
the Sabine case from the Court of Appeals last year on that issue?
I have not, Your Honor.
Well, it's not anything that would be on the front page of the New York Law Journal, I think, so it's not, but it's something we took note of it, and it seems to limit the jurisdiction, our ability to reach unpreserved issues under that exception. Now, we always have, we can always reach unpreserved issues in the interest of justice in the civil case, the Court of Appeals tells us, notwithstanding it's not in the CPL or anywhere else, but they told us we have that, so there's always that safety valve.
Along those lines, Mr. Mancuso, and this is you're here as appellate counsel.
Yes, Your Honor.
And, some of the argument that when you try to go back to explain it to your clients, I can see the difficulty in that. But part of the issue, as I understand, is on Article 78, it's somewhat unique. That is, the case law at least phrases it as such. That is, we do not have jurisdiction to consider issues raised for the first time or applied in Article 78. It's probably because of the nature of Article 78. They move fast.
Yes, sure.
That's what they're supposed to do.
Yes.
And so things raised in reply, they're considered to be outside the box. So you know where we're coming from.
Yes, Your Honor.
In terms of looking at that. Would you, for my benefit, take me to the conditions issue? And I think that's where you were going in terms of that, as I understand the argument below, you argued, again, I know you're here as appellate counsel, but what was argued below by different counsel was the conditions were wrong because you can't have those types of conditions for a type 1. But
Yes.
that argument doesn't apply if we conclude that unlisted action was appropriate. And that unlisted action condition argument wasn't raised below, I think, is the position that you're dealing with.
Yes, Your Honor. There are two, I would say, subsets of the CND argument. The first is what you have raised, Your Honor. Their focus below until reply was that you cannot utilize a CND as a mechanism for a type 1 action. So obviously, if this court concludes that none of the issues of whether this was properly classified as a type 1 action was preserved, then necessarily then that issue is not preserved for appeal. I would submit that the issue of whether it was a type 1 action has been preserved. And so as such, we've clearly preserved the issue of whether or not you can use a CND in a type 1 action. Now, separately from that is the idea that even regardless of the classification at all, you still have to follow procedural prerequisites to employ a CND. You have to use a full environmental assessment form. You have to coordinate the review. You have to publish in the EMB and provide 30-day comment period. We know none of those were followed. And so my position in the context of an Article 78 proceeding as well, because I did try to focus in my reply brief on the idea that even though in an Article 78, there is somewhat lesser of jurisdiction on appeal to address issues, and there are obviously concepts of waiver and preservation if you do not raise certain arguments in the context of an Article 78 proceeding below. There are examples of cases from this department and other departments on appeal in an Article 78 proceeding where they have applied that standard of law, the general rule to say if it's a pure issue of law on the face of the record, you may reach that issue if it is dispositive. And that issue in particular with respect to the CND, there are not many facts that are needed with respect to discerning on this record that they were not followed. And the planning board does not make any attempt to justify that to say that they did follow any of the procedures. I mean, we know they used the short EAF. That is clear in the record. They've certified to the completeness of the administrative record, and there are no indicators of coordination with involved agencies publishing in the EMB or a comment period, which is important in this case because as the court I'm sure is aware, the focus of the petitioners below was noise and lighting. Those were the two largest concerns that they had with respect to this project. And all of the conditions that they implemented in the negative declaration were really tied to trying to mitigate those potentially significant adverse impacts. Had they published, had they provided a comment period that would have given the petitioners and everybody else an opportunity to address the insufficiencies of those conditions, which would have forced the lead agency to either adopt a CND subject to review or to issue a positive declaration, which is what ultimately we are asserting should be provided. So I think sorry, Your Honor.
No, you did nothing wrong. I'm sorry to interrupt you, Mr. Mancuso,
No, that's
but is it fair to say, and you know that I'm pinning it down here a little bit, to be fair, is it fair to say if we overcome the preservation issues raised by Mr. Ginsburg, that your strongest argument you would say is the procedural as opposed to the substantive as vis-a-vis the hard look? Or do you think the hard look is the stronger of the two? Go ahead. You know what my question is.
I know what your question is, Your Honor. If we overcome the preservation, I would say that the procedural arguments, both of them are the strongest two arguments. And I would say that because unlike the hard look standard, this court need not afford deference to the agency with respect to the hard look. Strict procedural compliance is mandated under seeker, and you do not need to provide any deference to their reliance upon the voluminous record, because the voluminous record standing alone is not, a substitute for strict procedural compliance. The Court of Appeals and many other cases that have followed have said that proposition. So I would rely principally on the procedural points. And I would also couple that to say that, again, the planning board's response does not address the substance of those two issues. Their preservation is their defense to both whether they classified the action correctly and whether or not a CND was proper. They don't make a claim to say that the designation was appropriate. They don't claim a CND was appropriately
Right, most
adopted.
of their brief is dedicated to the merits of the hard
Correct.
look issue and four-town planning board meetings, and everyone was talking about these things. And
yes,
so yeah, we'll look at that very carefully. Anything further you want to add?
No, Your Honor, I will briefly address the hard look just because it obviously is a point in our brief, but I do think in this particular case, even overlooking the procedural violations, I still think there are some infirmities with the hard look that was taken by that board. Without using the full EAF, they did not pin down lighting and noise as preeminent focuses of the EAF process. And if you look at the condition negative declaration, what they really attempted to do was use a condition to mitigate an impact rather than study the impact up front. And ultimately, what they should have done is they should have studied through data and decibel levels associated with this facility. This is a unique situation. This facility is already constructed without approval. Oftentimes, what a lead agency is attempting to do is predict what a project may or may not actually result in an impact once constructed. We know this facility has caused an impact because it's already been built without approval. And so you have competing information in the record. Both sides are claiming that the owner saying the decibel levels are manageable. You have other members of the public saying they're not. Do a noise study. Actually pin down what the decibel readings are and evaluate whether or not that's a potentially significant adverse impact and whether or not there are measures that can be done through modification to eliminate the impact, not imposing a mitigation measure without any guarantee will actually solve the problem. And so I think that's an independent basis to annul the negative declaration, even if you obviously get over the obstacle of preservation on the procedural points.
So the argument really, I mean, they sort of are linked together insofar as you can use a conditional negative declaration to mitigate. That could be done as long as you follow all the steps within 617.7B1, which would be the full EAF, et cetera, all the steps that you mentioned. So then you could do it. You could take the planning board could theoretically take that strategy. You got to do a little bit more on the front end if you want to then use that mitigation strategy. They didn't do that. They didn't do what they needed to do on the front end or the back end. And so therefore that's why you brought the opinion.
Yes, precisely, Your Honor. Thank you.
Thank you, Mr. Mancuso. Turn it over to Mr. Ginsburg.
Thank you, Your Honor. May it please the court. The planning board here gave a hard look and rendered irrelevant any alleged procedural difficulties because it considered thoroughly all of the issues that my friend on the other side referenced, namely noise, lighting, wastewater management, and parking, as if it had done a full EAF process. The planning board specifically identified those four issues as meriting, quote, further scrutiny, close quote, beyond what a short form requires. That's at page 652 of the record. And it proceeded to give that further scrutiny to all of those issues. And I'll just discuss a few points on the salient issues briefly. As far as noise goes, The noise complaints and other concerns were discussed extensively in the meeting minutes. That was the basis of the planning board's compromise regarding that issue, to permit music only 4 days per week, 3 hours per day, has to end by 9 p.m., and has to be limited to 65 decibels or less. And contrary to petitioners' contentions, that compromise entailed the sort of conditions that this court and other departments of the appellate division have consistently found permissible. Those conditions were reached via a back and forth process. They were not conditions that were simply foisted upon the applicant at the end of the day. And the best evidence of that is page 230 to 234 of the record. This is from the August meeting before the actual resolution and site plan approval. There was a public discussion between Mr. Palladino, the applicant, and several of the planning board members discussing all these noise complaints, and should it be 65 decibels? Should it be 70? Should it be 85? Should the music end by 9? Should it end by 10, etc.? And collaboratively, this sort of compromise was reached. It is not a sua sponte springing up at the end of the day. That sort of condition the court certainly has struck down before. And the lighting issue, the condition there about dark sky retrofitting, was a similar permissible condition reached via this back and forth process. The evidence of that is at page 580 of the record. Some evidence of that, there's more than in the meeting minutes, but that page of the record, 580, is an April 2023 letter from the town code office to Mr. Palladino saying you should really consider dark sky retrofitting because that's going to be important in addressing lighting issues that might otherwise persist. And that's 4 months.
Mr. Ginsburg, Mr. Mancuso had argued with the hard look that suggested that the planning board was required to do a noise study and to do some other studies to gauge the impact of the outdoor lighting, more than just listening to complaints, and go out and do some investigation and some studies for the hard look. Do you think those types of studies are required for the planning board to meet their obligations substantively?
No, they're not required, Your Honor. It would constitute a harder look, or maybe a more perfect look, but they're not required to meet the obligations imposed by SECRA, particularly whereas here, in addition to the planning board members relying on their own experience and knowledge of the area and the venue, there is some scientific input, namely scientific input from the town engineer discussing noise issues and lighting issues. So it's not as if these issues are totally relied upon for lay people and that's it. You have the town engineer's input. There's also no problem on the wastewater management end with the collaboration of the town with the county health department. It is not, as my friend on the other side contends, an outright delegation to the county health department. The approval resolution, the board's approval resolution, makes county approval of a new wastewater system a necessary prerequisite for operation of the meat processing facility, not a sufficient one. It says no permits, COs, operation of the meat processing facility shall occur, quote, until the county gives its approval. That's page record 659 to 660. It doesn't say that if and when that approval is given, then it's off to the races as far as the meat processing facility goes. It still contemplates further action from the planning board and the town. And similarly,
where does it say that? Where does it say it contemplates further action?
It doesn't say those words. I'm saying that by setting up a necessary condition as opposed to a purportedly sufficient one, the resolution contemplates in so doing that the matter will come back to the board for further consideration. For example, Justice Ogden, if the resolution, instead of saying no operation of the meat processing facility until county approval, if instead of saying until, it said once the county has given its approval, then the meat of this new wastewater system, then the meat processing facility may operate, that would be a sufficient condition that I would agree with my friend on the other side would be an inappropriate delegation to an other agency to totally discharge the responsibility that is shared, at least in part, by the town planning board. but that's not what.
And Mr. Ginsburg, along those lines, to my recollection, the resolution said something to the effect of they've got to go get this wastewater done the way the county says it must be done, and as a prerequisite to applying for a building permit and a COO, a certificate of occupancy. Those latter are still issued by the town or the town planning board or the town engineer. So they're still got to come through the town, even once they're through complying with what the county says they must do for wastewater management. That's how I understood it, that they still had to come back to the town.
Yeah, that's absolutely right, Your Honor. And I paraphrased it. You quoted it much more eloquently than I did, but no permits, no COs, no operation until that approval is given. And then the application process for those sorts of permits still has to occur. So again, it's not an outright delegation of the board's responsibility to the county health department. And
does the town have any defense to the argument that it failed to comply with section 617D1 other than the fact it's unpreserved? Or is unpreserved the only thing that the town is relying on that?
On the parking space issue?
No, on the fact that they didn't do a full EAF, they didn't comply with the conditions, or they didn't comply rather with the requirements for a conditional negative declaration when you have an unlisted action.
Well,
6 NYCRR 617D1 raised only in reply. I appreciate that, but my question is there any other defense to it? Is to say, well, actually that doesn't apply in this case for some reason that I haven't thought of.
We haven't met their procedural arguments with a procedural defense. I agree with my friend on the other side's characterization. Our point is, though, as this court has endorsed many times in the appropriate case, that our consideration of all these issues, specifically the 4 issues that my friend on the other side addresses, was sufficiently robust and sufficiently done as if a full EAF process had been done, that it overcomes those procedural objections. And again, this court and its sister departments in the Appellate Division have said that when there's a full EAF review, something equivalent to a full EAF review, that those procedural arguments will not require vacatur of a planning board's decision. And so we rely on that argument here. And I think that I'll just conclude by saying that the consideration is similarly robust on the 4th issue out of 4 that the petitioners discussed, which is parking. The approval resolution there and the issue about parking for special events in excess of the 370 spots. The approval resolution there says that such parking, quote, is therefore not approved, close quote, as part of the site plan, and quote, must be reviewed with a specific supplemental site plan in advance of the special event. Now, contrary to my friend's argument, that doesn't show impropriety on the board's part. That shows diligence. It shows that the planning board recognized the need for careful consideration on a future case-by-case basis of whether and to what extent the 370 spot threshold could be exceeded, and that the board made the wise and restrained decision not to simply give wholesale approval at the beginning of the day right now with this approval resolution. So unless there are any further questions, I would respectfully submit that Supreme Court's judgment confirming the planning board's determination should be affirmed.
Thank you, Counselor.
Thank you, Your Honors.
Case number 873 is PE versus Erie County. Waiting, if we could just wait for Mr. Special. He is on the calendar to appear in person.
Yes.
He is remote. We'll welcome him remotely and he is ready to proceed. So Ms. Kubiak, you may start your argument.
Good afternoon, Your Honors. May it please the court, Melissa Kubiak, Herman Law, for plaintiff appellant. We request that this court reverses the lower court's decision dismissing defendant, respondent, child and family services of Erie County's dismissing them from the amended complaint. Plaintiff sought to add CFS as a defendant in her claim for negligent supervision brought under the CDA pursuant to 203, which allows amended pleadings to relate back to an earlier pleading so long as 3 prongs are met. CFS argues that the second prong, united in interest, has not been met because they are currently involved in litigation with the original defendant, Erie County. But this argument misconstrues what it means to be united in interest.
Before we get too far into the united in interest in the second prong, do you care to address the third prong?
Sure.
With respect to notice, that seems, I know your office has been on a lot of these.
Mhm.
You've lost on notice on a couple of others. My understanding of the case laws as it's been interpreted by this court is that there has to be some actual notice by the new party, here CFS,
Mhm.
that the plaintiff sued the county, some knowledge of that lawsuit,
Right.
actual knowledge. The burden is on the plaintiff here to present some evidence.
Correct.
Is there any evidence here that CFS even knew that the plaintiff, your client, had sued Erie County?
Yes, and I have two ways of looking at it that you could find notice to CFS. First, the case Ellis v. Newmark highlights the issue of the second prong regarding vicarious liability existing where there is indemnification clauses, which is here, given that there's the third party claim now. The court continued in Ellis that the evidence to indemnification obligations supports a finding that the proposed defendants can be charged with having notice of the commencement of the action. The very existence of that clause that has now allowed the third party suit to come into play.
Because they agreed to indemnify back in the 1970s when they agreed to the clause, that would then give notice in 2000 whatever that the claim exists?
That's essentially what the Ellis, that it supports that theory is what the Ellis court concluded.
I took a little closer look because you cited in your brief the Haidt case, H-A-I-D-T,
Yes.
in this court.
Yes.
You relied on and quoted. I have it in front of me. It looks like in this case, in terms of the actual notice, the Haidt court noted, first of all, it was unpreserved in that case. And second of all, they wrote defendant received notice of plaintiff's claims at the same time as an original defendant, or perhaps the original defendant, if there was just one. It looked to me as though you were arguing that Haidt stood for the proposition you don't have to give actual notice at all. Or that the other, the other defendant, the new defendant, I suppose we'll call it, doesn't need actual notice at all, but it doesn't seem to me that Haidt supports that.
Yes, I would argue now that what Haidt is establishing is that because of the circumstances of that case, there was a provider that prescribed medication. And that was the one that they wanted to bring in, because the act of actually prescribing that medication puts them on notice that they did something. And like here, CFS had a social worker that my client complained about the sexual abuse to back in the 80s and early 90s. It was their employee. That's actual notice.
I see. So it's the complaint to the employee. It's not the fact that they had an indemnification agreement. It was the complaint to that's what triggered it.
Sure.
Where do we have evidence about the complaint here in this case?
Well, we're in the discovery process still, which is why we feel that it's inappropriate to dismiss.
And who else would make the complaint?
Right, correct.
So all you would need is an affidavit from the plaintiff saying, back in the 1980s, I made a complaint.
Yes.
But where is it? Where do we have that affidavit or that allegation?
I am not sure if that affidavit has been made yet. It's part of the original complaint. Those facts.
Well, the allegation of the abuse is part of the original complaint.
Yes.
The fact that I complained to the provider. Is that it? Is that it?
The social worker is mentioned in the complaint.
Verified complaint, and the complaint says I complained to the social worker back at the time, and we can determine that person would have worked for Child and Family Services based on what we found out after the fact.
What we found out so far, that CFS was the one managing her foster services.
Okay. Was that argument made in Supreme Court? Was that argument made to the court below that, the verified complaint alleges that a complaint was made back in the day?
I don't believe so, but I don't have that in front of me right now, so I can't speak positively to it.
Yeah, I thought, and Well, you deal with this all the time. I don't, but I thought the third prong dealt with actual notice of the actual lawsuit, not of any torts committed a while ago, any negligence.
Well, so, and that's where Ellis kind of brings in the idea that because they are united in interest, because there is a claim there, that the indemnification obligations between the two of them in of itself allows for the notice. It supports the notice.
Not the claim, not the negligence. Is there an indemnification? I thought that there was nobody was able to find a copy of a contract here between the county and CFS.
At this point, I don't know. Things have been coming in slowly, not upon our requests. So I'm not sure if
But you were saying that there's contractual indemnification here.
Well,
the hook for, but we don't know if there's a contract.
We're assuming that there's a contract giving the litigation between those two now.
Well, that contract is for contribution. I mean, that third party action for contribution.
I'm sorry.
My reading of that complaint, third party complaint, is that the county seeking contribution, not indemnification.
But it's going to be based on the indemnification that they would have agreed to back when the county contracted CFS.
Maybe I missed, well, okay, yeah. They do allege a written agreement here.
Just getting back to the argument you just made to me a moment ago, this notion that there was a complaint made back in the day. I'm looking again at your brief and it says, in terms of the actual notice you wrote, likewise, here CFS received notice by virtue of timely service on Erie County. So it looks like in your brief, you're not even making the claim about notice to CFS back in the day. You're talking about the complaint filed against Erie County. Somehow CFS was aware of that and then should have put two and two together and said, the plaintiff made a mistake here. We're going to be included in this at some point.
Yeah, I think that's what the reply itself, or the brief, the original one, it stops short. It doesn't give a thorough analysis of it, and I apologize for that. But
look, we get it's a hard burden to meet for the plaintiff to show what the new party knew or didn't know about the lawsuit. You would think that the other side should be required to say, we didn't have any idea first. I'm not sure they're even saying that.
No, not at all.
They're not denying it, but you have the initial burden. That doesn't seem right. Do you, with the second prong, it's subject to a lot more confusion with this vicarious liability. We know now that vicarious liability doesn't automatically mean two parties are united in interest, but it's a factor, it can be.
Right.
You seem to suggest that there is vicarious liability here based on an agreement that we don't have yet, some written agreement, contractual indemnification. Is that what it is? Or how are they vicariously liable?
They're vicariously liable just by way of, there was a contract between the county and CFS. They contracted out all of the foster care services. Just the fact that the county is saying, we don't have any records right now. And then through our digging, we found that CFS is the one that has records, is the one that provided those services. And it's a non-delegable duty for the county. But I'm sorry, Royce Broadmoor clearly establishes that non-delegable duty to the child in its custody creates vicarious liability for the parties that it contracted to do those services.
So the defenses are aligned. You're saying that there's no adverse defenses here between CFS and Erie County?
For our particular claim, no, they have the same defense.
Couldn't the county say, hey, that's your fault, CFS, you were supposed to do that, not us?
Sure, they can point fingers, but at the end of the day, it's non-delegable, so I cannot say that one.
Ms. Kubiak, I have a series of questions, so you just got to be patient with me while I map it out my notes. You started your argument, as I understood it, when you were asked by the justice presiding with respect to prong 3. You said there's two ways to find notice, and you went to, I think, the Ellis case.
Yes.
And then you said that the indemnification / vicarious liability as united in interest would get you there on notice. And then you didn't get a chance to give the second grounds of why there's two ways to find notice. And I'd like to get that from my notes, but then I do want to go back to Ellis real quick. So
Sure.
what's your second one from my notes here?
So the second one, I bring in hate there. Talking about a provider, the provider does the thing. It writes the script for amoxicillin or what have you. The plaintiff in that case, I believe, made the suit against their actual doctor, not the individual that wrote the script, because they thought, it's my doctor. But the person writing the script, once they found out the doctor was getting sued, is like, oh, I wrote that script. I'm going to be involved in this, chances are.
Sounds like that's the same thing as the Ellis case that you argued a second ago in response to. Maybe I've got it confused, because I know that Justice Nowak asked you about the Height case, I think it's called. But so I'm still trying to write in my notes what the second way to find notice is. And I'm sorry to pin you down, but you did start that way. So
Yes. So I'm viewing them separately. In the Ellis case, the court is saying the existence of the indemnification obligations support a finding that the proposed defendants are charged with having notice of the commencement of the action.
fair enough. Forgive me. Let me phrase it my way. And if I get it wrong, correct me. Okay.
Right.
Now I get it. I think the two ways to find notice is under the Ellis case with respect to indemnification and vicarious liability.
Correct.
The second is where Justice Nowak took you on the Height case, where there was actual notice vis-a-vis what occurred in the 1980s, where your client purportedly notified CFS or the county of a complaint of being a child victim of sexual abuse. Okay, so let's break those down. On the first one, if you claim that under Ellis that indemnification vicarious liability is always going to be basis of actual notice, then that's always going to be actual notice in every case, because in every one of these cases, you're going to see the county go after on some form the co-provider,
right,
the delegated provider. So it seems strange to me to say this, to distinguish between united in interest and vicarious liability and the third prong, if they are in a sense one and the same. So therefore, actual notice always exists when there's a question of fact on the second prong. Is that your argument?
When you word it that way, I think it would be unusual, not impossible, but unusual to find an instance where one doesn't flow into the other. But in most cases, I think, especially in this set of circumstances, they do.
And if you have a very strong vicarious liability argument, you don't even need CFS as a practical matter, correct? Having them in for indemnification, contribution, as third-party complaint, they're going to be on the verdict sheet because the county is going to want them there.
Correct.
Okay. Put aside the practicalities. Now, so on the second thing, in the Height case, where you try to rely respectfully on the notice during the 1980s to make up a time frame, and following up on the Justice Presiding's question, I think our case law, maybe your firm was on our case called CRJ.
Yes.
Versus Oswego County. I printed this out this morning. It says plaintiff failed to present any evidence establishing that the entity in question had noticed that an action had been commenced. So with respect to this Kubiak, the language there is exactly what the Justice Presiding said a minute ago. It's not about what was complained about in the 1980s. It's about, and I'm also with the Justice Presiding, I mean, to require actual notice of the action was commenced is a very difficult burden.
Right, and I would just add this one thing.
Yeah, please.
Nemeth, that comes from Nemeth, the Court of Appeals. They went on to talk about that, and if you read practice commentaries to 203, Vincent Alexander goes on and makes it clear we're talking about actual notice of the lawsuit.
Can I follow up on that?
You may.
Do you have that here? What's the evidence in this record of actual notice to CFS of the commencement of the lawsuit? Just so you know where I'm coming from, Ms. Kubiak, I don't see it, so I need you to help me find it, if it's there.
We did not write a letter to CFS not knowing that they had been involved. We did not serve them until after we found out that they were involved. I can't fault our client for not knowing the actual company that was managing her foster care services when she was, 7 years old. I think that to ignore the contractual relationship between the two parties would be doing a disservice, and it would just allow the county in this case to essentially run defense long-term for anyone it contracted, knowing full well that's who we contracted. But we'll just let the statute of limitations run out for their sake. And then
in your defense, we understand you subpoenaed the county. We want information on whoever you contracted with for foster care homes and review, and they had no records.
Yeah.
Then the statute of limitations runs. You, and through your own, go to the Buffalo Psychiatric Center and find out, oh, CFS is involved. So there was no sleeping on rights here. Your firm was on this. The county didn't know apparently about CFS. That seems odd. So that's why you're in this. So we get that, and we get that the burden's kind of high on that third prong. So we have to take a look at whether there's some way around that based on this Ellis and these other theories that you have espoused.
Yes.
All right, thank you.
Are there any other questions? All right, thank you.
Mr. Special, can we start with a question? Your brief relies, you talk only about United Interest prong 2. You don't get into prong 3 with a notice. Is that, why is that? Is that intentional?
Right. So thanks for asking, because that's actually really, to me, from just my perspective and being in the case, it's very hard to see where we would be united in interest with the county. So that's why I really went that way. And just as Curran earlier had mentioned, just the practicalities of this, and so I wanted to touch on that, because what I think, and this might be partly my fault too, I think we all have been missing the forest for some trees on the united in interest standard and what it is. So in this case, let's say you affirm based on some of the cases that I cite that say if there's competing defenses, there's no unity in interest, right? So if you affirm on that, for instance, my client is still going to be in the case as a third party. Definitely going to happen. We can't get out of that with a motion to dismiss or anything like that. So we're definitely going to be in the case. To defend ourselves against that case, we're going to be trying to shift blame to the county. So my client is a nonprofit. So I would have thought that plaintiff would have preferred us trying to shift the blame to the party who actually has the money to pay. And that to me is why I just can't see how we're united in interest with the county, because we're in totally different positions than
Right, your defense is it's the county's fault. The county's defense is it's CFS fault. And those are antagonistics that necessarily follows you're not united in interest. Is that the theory here?
Yeah, very much. I think we're more adverse to the county, or I should say rather, the county is more adverse to us than the plaintiff is. I certainly think that we will end up fighting more with the county than plaintiff in this case.
But don't you have to look at the claim? I mean, the claim here is not that the child was placed in foster care through CFS, and then, the county stepped in and maybe transferred the care to somebody else, or the county did something in their role, which was separate and apart from CFS's role. It's simply that while they were in the foster care situation, the plaintiff was abused by somebody who was in the foster care home. And so the claim against CFS is exactly the same as the claim against the county. Nobody protected me from this person in the foster care home. It seems that the claim's exactly the same. If CFS isn't responsible, then the county's not responsible. So then that's where we have the vicarious liability. If we have a situation where the claim goes far afield and say, well, it's not because of the foster home, but it's because of X, Y, Z, and you could say, well, that was the county's responsibility. They'll say that was CFS's. Then I appreciate we have this distinction. But here, do we really have a distinction based on the allegation?
So, yeah, Judge, I mean, you have a good point, but I think there is a distinction here because ultimately the county, for example, like they're ultimately responsible for certifying the home and things like that. I mean, in a sense, I would almost compare it to like they're like the ultimate like supervisory role, right? So, um, it's possible that my client, and this is going to be our position, didn't do anything wrong at all, and ultimately the plaintiff failed when because they would ultimately make the choice to certify this home and send plaintiff there. Essentially, so I do think there's a difference. It's not like in a sense like vicarious liability like some I've had with police officers and the departments where like they're completely on the same page where the department says we didn't do anything wrong and our officer didn't do anything wrong and there's no issue here. I've had those, and in those cases I think they definitely are united in interest. Were in all the ones that I have had with the officer or the department, we're always on the same side there. Here I do not view this as being on the same side as the county at at all. Because ultimately they do have more control over all this than we do as just a nonprofit, and they're the county.
I understand the argument. I guess getting back to the Justice Presiding's original question, based on the fact that we have nothing on prong 3 in your brief, does that equate to a concession that, yeah, well, we had actual notice of the lawsuit, but we're focused on unity of interest? Is that a concession on point 3? Should we?
No. I wouldn't say that at all. We had went through all of them in our papers in the trial court, so we can test that. But I just wanted to go in the unity of interest test because that's where I really felt strongly because I just can't see how we are.
Right, you were confident you were going to win that. You don't even need to get to 3. But did the trial court? I don't think we have an explanation in a record of the reason for the trial court's decision here. Was there an oral decision from the bench, a written decision not included in the record? What did court say here?
Well, there was, and I know where he was going, but he did not put it on the record, so I don't know if I can tell you or not. I mean, if you say it, I can. I'm
So
happy
off
to.
the he made a ruling. Well, did he give explanation for the ruling off the record?
Yeah.
What was the purpose of all that?
So I don't know if you recall, but there was another case that was just like this. You heard it a couple months back. That was together.
CG.
It was CG, right? So in that case, there was evidence that the plaintiff had made an effort to determine the identity of CFS prior to the expiration of the statute of limitations, and here she didn't, because, and where Judge Furlong was going, my understanding was he didn't want to put that on the record because he didn't want counsel to be blamed for it because it really wasn't their fault. It was plaintiff who just didn't. When she first thought to bring this suit, she just didn't do anything to identify CFS prior to the expiration of the statute of limitations. Basically, was what he said.
CG was basically a substitution under CPLR 1024. We never reached the relation back out.
I mean, well,
different standard.
Right. So that was the hard part for me, because I mean, me personally, I don't think that CG or AS is right, but that's what you decided, so that's what I'm working with now. It's kind of like a moving target for us now, because we never know which one they're gonna use. And it's like, I mean, so they filed this, actually their first brief, I believe it was the same day after we argued CG, and here, so I had appeared here talking about 1024, and then 2 hours afterwards, I think it was that, or it might have been 2 days later, all of a sudden I have to deal with the same case under a whole different thing, because they're being treated as basically the same thing and interchangeable, which I personally don't think they are, but that's a whole nother story.
All right. Well, thank you, Mr. Special, for your, appreciate it. We'll move on to case 875 of Citibank versus Gifford. 875, counsel for appellant is remote. Respondent has submitted. Counsel, you may proceed with your argument, keeping in mind that your opponent has submitted. And you may unmute yourself if you would.
Good afternoon, Your Honors, and may it please the court. My name is Nicholas Tessany. I'm with the Legal Aid Society of Mid-New York, and I'm here representing the defendants Thomas and Marlene Gifford. The Giffords bring this action to secure their rights to raise the defense of lack of standing secured by the state legislature through the Real Property Actions and Proceedings, Chapter 81, Article 13, Section 1302A, which was made effective December 23rd, 2019. Which was a major departure from prior law, CPLR 3212B. Essentially, what this law did was secured the rights of the borrowers in a foreclosure action to bring the standing defense so long as the sale of the property had yet to occur, and so long as the defendants were not in default as part of the court proceedings. In this situation, the defendants both filed answers May 13th, 2019, so they were not in default. And obviously, this is a foreclosure action for their home, meeting the standards required to apply this law.
So can I interrupt you real quick with a question? Has the property been sold in foreclosure?
No, it is not.
Your client's still living there?
They are still living. They are currently paying a bond of $2,000 a month during the pendency of this action.
They're paying a bond as of now. They defaulted in 2017?
Correct, Your Honor.
And then they went 8.5 years without paying anything?
So after a certain point, the bank wouldn't accept additional payment. They were.
Right, so they've been. Who's paying property taxes?
The bank, Your Honor.
So your clients have been there, they were there for 8.5 years, not paying a penny for anything? Actually, I'm just trying to get the background here. It's not legally relevant.
Sure. So they defaulted in 2017. The actual foreclosure case wasn't filed until April 18th, 2019. So about 2 years into the foreclosure case was actually filed. The courts listened to an argument for summary judgment in 2020. Obviously, certain things were put on hold due to the pandemic. And then an appeal was filed in March 2021 with a decision in April 2021. And
So if they prevail here, they get to stay and not pay for longer?
if they prevail here, ideally, our argument would be that our argument is that the bank does not have standing to bring this action, and they would essentially be getting their home. They've paid hundreds of thousands of dollars at this point on this loan, and at this point, if the bank doesn't have standing to bring this action, they would get their home free and clear.
There's already been a judgment, correct, on this?
So there have been.
And that wasn't appealed from, is that accurate?
Correct. There's been a judgment of, so there was a summary judgment that this is appealed from, that I believe was from sometime last year. That was when my firm was involved with this. We were the original attorneys on this case, so I'm not familiar with how the case progressed before we took over, but we filed our summary judgment in opposition, and the lower courts followed the previous appeal and applied that law for the summary judgment of the plaintiffs.
But counsel, in the other judgment, what didn't we decide that your clients waived standing?
So yes, the original appeal stated, I believe the exact quote was that under 3212B, having failed to interpose an answer which asserted the defense of lack of standing, or file a timely pre-answer motion raising that defense, that the defense of standing was waived by Thomas Gifford. However, the case that was referred to in that was HSBC Bank versus Schwartz, which was a case from 2011. The law that we are referring to now was in 2019, which was made effective December 23rd, 2019, with this original decision being made in with the original decision being made in April of 2021. So the law of 1302A should have been applied in this case, and the defense of lack of standing shouldn't have been made waived by the appellate court.
We understand.
Mike, I have a question just in regard to following up on Justice Kane's question. I'm not sure if Justice Kane was referring to summary judgment, which was some time ago. I think what she may have been referring to is that we had the date of the decision in order, May 2nd, 2024. That's what you're appealing in this case.
Correct. Yeah. So we have.
Hold on one second. We had a judgment issued the same day, and there was another notice of appeal filed for that judgment, but that's been administratively dismissed. Is that right?
Correct. Yes.
Okay, but there's still, I think there may still be time for that to be, for there to be a motion to vacate that if you want. I mean, I suppose it's up to your client, but the thing is, once the judgment issues from the decision in order, can we decide the appeal on the decision in order, or don't you have to appeal from the judgment?
So in this situation, you should be able to appeal from the decision in order. The judgment is currently stayed pending the appeal of this action.
All right. Thank you, Counselor. Take a look at it.
Thank you.